Right. Good morning. This is the matter of AW, case number 24-51041NA. Present in the virtual courtroom, we have the child's attorney, Mr. Kasorek, and the mother's attorney, Ms. Coletti. We have various agency workers as well as a foster parent and the CASA. Mr. Kasorek,
Thank you. I would like to call Miss Star Thurman, please.
would you raise
Hi.
your right hand? Good morning. Would you state your name and spell it for the record?
Hi, my name is Trayana Star Thurman, Crayanastarr-Thurman.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Kasorek.
Thank you, Your Honor. Miss Thurman, you are employed by Wellspring Lutheran Services of Kentwood, correct?
Correct.
And you are the caseworker assigned to AW, correct?
Yes.
All right. For this hearing, you submitted to the court and counsel several exhibits, and if I simply could list them, Your Honor.
That'd be fine.
Number one being the case service plan with PAAs and honorable judge report dated 7/21 of 26. As proposed, number two, there is a very thorough CASA report dated 7/28 of 26. As proposed, number three, there's a single forensic fluid screen for the mother, Miss Woodenberg, dated 7/9 of 26. And as proposed four, there's a packet of forensic fluid screens for AW.
Any objection?
No objection.
All right, they're admitted.
Thank you. Ms. Thurman, can you update the court on the well-being of AW? Let's start with her, any issues medically or dentally.
Currently, AW is up to date with her medical and dental needs. She does have another well child scheduled for August this month. At the end of this month. She's overall doing really well. I do feel like when she AWOL'd, she was not med compliant as she didn't take her meds with her. However, at this time, I do believe she is being med compliant with the meds being in the current caregiver's home.
All right, that's a good sign. AW, of course, is 17, correct?
Correct.
And this is, I think, her one, two, three, four, sixth placement.
Correct.
And when did this placement occur? And can you just tell the court just the background of what happened?
Yes, this placement officially occurred on July 9th of this year. Originally, she was placed in a fictive kin prior to that home, and she did not feel that the parenting style was very trauma informed and it was very just triggering to her. So she did end up AWOLing to one of her really close friends' home. And since then, she has been able to be placed with that friend's grandmother. And I do believe that she's doing really well there. She abides by the rules. She's allowed to have prudent parenting styles there and overall just be a teenage girl.
All right. How about her AW's mental health and substance abuse issues? Can you tell the court a little about that?
Yes. During this reporting period, I think that AW has not been complying with her mental health treatment with therapy. She has set sessions. However, she hasn't been able to attend. I am guessing it's more so because she's been very busy this summer doing different activities. I do plan to meet with her therapist on trying to coordinate a better set schedule, maybe scheduling through the caregiver or the case manager just to make sure that she is attending those sessions. Her substance use continues to be a need at this time. She does still actively use marijuana. She has tested positive on all 5 occasions during this reporting period. We did have a little break of testing in June due to the AWOL situation and not being able to get a hold of her to test her. She has expressed a desire to want to quit, but she just has not taken that initiative yet.
All right, and that's been something that has been talked about and has been attempted to be addressed for some time now, correct?
Correct.
All right. What is your plan to address the issue? Do you have a referral that's been made to any substance abuse treatments?
I know that the previous caseworker did a referral to Wedgwood, and she has since been discharged from them due to no call and lack of participation. She doesn't feel that program suited her. So I really would like to sit and talk with you and myself and AW just to figure out what she believes that she could do because she is a 17-year-old girl and she's able to make her own decisions. And I feel like we need to include her in this case more so with her substance use to get her to comply with quitting.
Right. And that, of course, goes hand in hand, the substance abuse issue with THC and her actual wanting to be able to drive.
Yes,
And there is currently a court order indicating that until there's a substantial period of sobriety, she may not drive, correct?
correct,
And we were hoping that that would be some sort of an incentive for AW, correct?
correct.
And it hasn't worked very well, has it?
No,
But we'll work on that still.
yes.
All right. Does she have contact with mom? By reading over your reports, it seems that she does. And by reading over your reports, there is an indication that she would like more contact with mom. She would like unsupervised visits with her, and likewise, she would like to go back home to her mother's care, correct?
Correct. At the beginning of July, Miss Woodenberg reached out to want to participate in services again, and since then we have held FTMs and TDMs to engage her back in those services, and they have returned to doing parenting times.
Has Miss Woodenberg actually rescinded her non-participation agreement?
I have not taken it over there. Yes,
Has
sorry. Yes,
she? Okay.
yes.
All right. Wonderful. Um, and how do the parenting time with Miss Woodenberg go for AW?
The parenting time with AW and Miss Woodenberg through the case AIDS eyes, they go really well. They're extremely well bonded, but I can talk more so because I was able to watch one of those visits and I feel like it went really well. It was at the home. They were extremely excited to see each other. They talked about shopping, they talked about school, they played board games with her sibling and her mother, and then they just overall just seemed really well bonded. And when it was time to go, I myself was extremely sad to have to end that visit because it just was a great visit.
All right. And likewise, has she seen her little brother, RJ?
Yes, he's there at those parenting times.
And I'm assuming that the interaction between AW and RJ are just great, isn't it?
Yeah, they're just siblings.
All right. Can you tell us a little bit about AW's education, continued education, and where she will be attending school?
Yes, so previously she was attending East Kentwood High School. She was in the 11th grade and she was taking summer school classes to catch her up on some of those failed classes so that she could be able to graduate this year. She has since been lacking in her summer school. However, she is transferring to a new school. So I plan to coordinate with that new school, Union High School, to see where she lands with their academic program and see what we need to do to get her able to graduate. She originally was um, enrolled in an EMT program through KCTC. So I want to talk to Union because I know she really wants to do that, but I'm not sure if that school offers that service too.
And your communication with AW is pretty good, isn't it?
Yeah,
All right. She does like you and she trusts your opinions.
I believe so.
All right. You are aware that, uh, well, let me ask you this. Is she still in contact occasionally with her prior uh, foster parents that live outside of uh, Grand Rapids?
I do believe that during that AWOL situation, she was in connection with them. I'm not sure as of right now. I would imagine so because she loves them a lot.
Okay. And that contact should continue because I'm sure it's very supportive for AW.
Yes.
All right. Um, Anything else about AW?
No, other than she really wants to be back home with mom.
Okay. And at this point, because she is 17 and can make at least a majority of her decisions besides driving and using THC. You think, is she making the right choices for herself?
I do, other than the substance use, yes.
Okay. Um, and Miss Woodenberg is actually involved in visiting AW right now, and she's appropriate with her.
Yes.
Do you believe that unsupervised contact with the mom would be appropriate at this time or not yet?
Yes, I do.
All right, and why is that?
I believe that, again, AW, she's a 17-year-old girl. She loves her mom. She knows right from wrong. She's been stating that she has a really strong desire to see mom. I've watched a visit. She's been having visits. Mom is doing really well. She already has been reunified with her child. She's very sober. She participates in drug screens, and and I do believe AW is able to advocate for herself and tell us when she does not feel safe.
All right. So at this time, what are your recommendations?
It is respectfully recommended that AW remain a temporary court ward under the care and supervision of DHHS and Wellspring Lutheran Services. AW remain placed with a relative placement or a licensed foster home. All parties comply with and benefit from the parent agency treatment plan. Ms. Woodenberg's parenting times remain supervised or unsupervised by the agency or its designee. A dual order be in place for a return home when deemed appropriate upon FRP services being put in place, and this matter be reviewed in 90 days.
And let me follow up on that last recommendation. Currently, the permanency goal for AW was APLA. Are you suggesting that we consider changing that goal?
Yes.
All right, thank you. Nothing further.
I'm just going to address that issue so that I don't forget. This was not noticed up as a permanency planning hearing. Ms. Coletti, would your client have any objection to us conducting a permanency planning hearing so that the court can consider changing the goal at this time?
There would be no objection, Your Honor. I think that's
Right.
in the child's best interest.
All right, Mr. Kisorek, you want to?
Thank, yes, thank you. Ms. Thurman, let me ask you the permanency planning questions. With the return of AW home to her mom today cause a substantial risk of harm to her life, physical or mental well-being?
Yes.
And that's because we still need to do some work on the relationship between AW and her mother, correct?
Correct.
All right. Do you believe that initiating a termination proceeding would be in the best interest of AW?
No.
And that's because she is 17, she doesn't wish to be adopted, and she wishes a reunification with her mom, correct?
Correct.
All right. Has the out-of-home placement uh, followed the prudent parenting techniques as defined in the statute? And has AW had the regular opportunity to engage in uh, appropriate activities for a child her age?
Yes.
All right. Can you give us an example or two, please?
AW is able to go hang out with her friends. She's able to go shopping. She's able to do other activities in the home. And overall, that's pretty much what she does.
All right. Thank you. I have no further questions, Your Honor.
Thank you, Ms. Coletti.
Thank you. So Ms. Starr Thurman, she did revoke the MPA, the non-participation agreement in July?
Yes.
Okay. And so the goal now is she's actively working the treatment plan?
Yes.
No concerns about her sobriety?
No, she's tested negative on every occasion.
Okay. So there's nothing she's not doing on her treatment plan, correct?
Correct.
Thank you. I have no other questions.
I actually have one which Ms. Starr Thurman may or may not be able to answer. Do you believe that if Anaya were reunified with her mother, that Anaya's current substance abuse struggle could have a negative impact on Ms. Woodenberg's sobriety herself?
I feel like that's hard to answer. I think that Miss Woodenberg's sobriety was alcohol based, so I would want to say no, and I would want to say that she's been so positive in her recovery and everything, so I don't believe it would. But again, We can
I know, I realized it was not really a
Sure.
fair question, but I thought I had to ask it. So,
Yeah, we would definitely safety plan for that though.
okay, thank you. Any follow-up, Ms. Coletti?
No, thank you, Your Honor.
Mr. Kisorik?
Yes, Your Honor. Ms. Star Thurman, have you discussed the issue of the concerning substance abuse of AW with Ms. Woodenberg and how she could help out her daughter?
Yes, I have.
All right. And can you tell us what her responses were?
She's basically doing the same things everyone else, all the other supports in Anaya's lives are. They're trying to encourage her to quit. She tells her what she's been through and how to quit, but again, it's ultimately Anaya's decision. She tries.
Thank you. No, nothing further, Your Honor.
All right, Ms. Coletti, any follow-up?
No, thank you, Your Honor.
All right. Mr. Kisorik, any additional witnesses?
No other witnesses, Your Honor.
Ms. Coletti, any
No,
witnesses?
thank you.
All right, Mr. Kisorik, statement?
Thank you, Your Honor. It's been a little limited in my contacts with AW lately. I think for some reason she, just like with CASA, she simply uh, doesn't wish to have contact with us, at least on a regular basis, which is a little bit concerning, but I understand she just is a 17-year-old who wants to lead her own life and who wants to be reunified. Um, I'm going to, I guess, attempt to contact her and do an in-person meeting, Your Honor, within a few days, if the court will allow me that, and I can then submit a report. Thank you. The recommendations are, and a goal change is appropriate in my view at this point.
All right, thank you. And are you open to Ms. Star Thurman's suggestion that you and she meet with AW to discuss a potential plan to address the substance abuse?
Absolutely, Your Honor.
All right, thank you. Ms. Coletti?
Thank you, Your Honor. I support the recommendations. I believe they're appropriate.
All right, thank you. The court finds that the lawyer guardian ad litem has complied with the requirements of the statute. I understand that Mr. Kasork has made multiple attempts, and that the fact that he has not had direct contact with his client is due to her choice, which is unfortunate. But let's see, that returning AW to a parent would cause a substantial risk of harm to the child's life, physical health, or mental well-being. That this child has been in foster care for 15 of the most recent 22 months. And the agency should not initiate proceedings to terminate parental rights for the compelling reason that the child does not wish to be adopted and is of an age where due consideration must be given to her wishes. The reasonable efforts have been made to preserve, reunify the family, make it possible for this child to safely return home. That in accordance with the statute, progress towards alleviating or mitigating the conditions that caused this child to be placed or remain in temporary foster care has not been made, or I'm sorry, has been made by Ms. Wittenberg, has not been made by the unknown father. That AW's continued placement is necessary and appropriate in meeting this child's needs, but will no longer be necessary or appropriate once FRP is in place. That the needs of AW can be met in a foster family home. That reasonable efforts have been made to finalize the court-approved permanency plan of APLA. That permanency planning goal is no longer appropriate and shall be concurrent return to a parent and placement in another planned permanent living arrangement. That the foster home has followed the reasonable and prudent parenting standard, and that this child has had regular opportunities to engage in age or developmentally appropriate activities. The court orders that AW continue in the protective temporary of the court, continue placement with the Department for Care and Supervision, that she be placed with mother under the supervision of the department once FRP is in place. That the adjudicated respondents comply with and benefit from the case service plan. That parenting time of Ms. Woodenberg be unsupervised. I'll continue the appointment of the attorneys. I will also continue the order that AW not be permitted to drive until there's a pattern of clean drug screens. And do we have a date for our next review hearing, Ms. Gibson?
Yes, Your Honor, October 28 at 11 a.m.
Any conflicts with that date or time?
I'm looking, Your Honor.
I don't, but if Kendra does, if Kendra's a conflict, I can cover her. I'll let her know that.
Right,
What time is it? 11?
11?
Yep, that'll work. Thank you.
Okay. And I guess I would indicate also that if Anaya agrees that, or I'm sorry, AW agrees that Ms. Gleason also be included in that meeting with Mr. Kosarik and Ms. Star Thurman, I think extra, support and help in figuring out what the best path forward as far as substance abuse goes is appropriate. All right. Anything further?
Not for me, Your Honor. Thank you.
Good morning, Ms. Swears.
Good morning, Your Honor. We are here this morning in the matter of McCade and Andre. This event is scheduled as a delinquency final pretrial conference. Present today is McCade and Andre, her father, Craig Johnson, her attorney, Steve Simpkins, Brent Green, guardian ad litem, Melissa Powell, the city attorney. We also have Peter Drent, APA, and myself, Lisa Swears, intake probation officer.
Great. Good morning. This was scheduled for a final pretrial, but it's my understanding that the parties have reached a plea agreement. Is that correct?
That's correct, Your Honor. That's correct, Your Honor.
All right. And Ms. Powell?
Your Honor, in exchange for an acceptable plea to one of Ms. Andre's offenses charged under the state code, the city has agreed to dismiss our offense.
Mr. Drent?
Correct, Your Honor. It'll be a plea of no contest, and the basis for the no contest plea would be lack of memory. And that would be to 25-51842-DL. The basis of the plea would be Kentwood Police Report 2521493.
Thank you. And Mr. Green, do you believe that the plea agreement is in the best interest of your client?
I sincerely do, Your Honor.
All right. McCaden, can you move the phone so that I can see your face and that there we go. Would you raise your right hand, please?
Yeah, raise your right hand.
The other one. There you go. Would you state your name and spell it for the record?
McCade and Andre, McCaden,
Okay. Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
the truth.
Is that a yes?
Mm-hmm.
Okay, you got to say yes or no. This is being recorded.
That's a yes.
Okay. Thank you. You can put your hand down now. And are the parties willing to waive the reading of the petitions?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
All right. And McCaden, do you understand the plea agreement?
Yeah.
Yes, sir, yes.
And do you understand the charge of resisting and opposing a police officer?
Yeah.
Yes,
Okay.
sir, yes.
Do you have any questions about that charge?
No.
Okay. In a few moments, I'll be asking you whether or not you want to plead guilty or not guilty to this charge. And if you plead guilty, you're saying that you did it, and you're willing to accept the consequences and the punishment. Do you understand that?
Mm-hmm.
Is that a yes?
Yes, sir, yes.
Yeah.
Okay. If you plead guilty today to this charge, you understand that the worst that could happen to you is the court could make you what's called a ward of the court and place you in a juvenile institutional facility until you're 19 years old.
Mm-hmm.
Can you say yes or no?
Yes.
Yes.
Okay. There are also many possible things the court can order you to do, such as place you on probation in the home of a parent or in a foster home. The court can order you to attend school, take part in psychological or substance abuse counseling and evaluations, take part in the court work program, or make a charitable donation. Do you understand all of those things?
Mm-hmm.
Can you say yes? It's really important if you
Yes.
yes or no, and it's okay to say no, okay?
Yes.
Okay. If and only if you deny the charges in this matter, will the court schedule a trial for you. However, if you admit your guilt to this charge, you will not have a trial of any kind and will therefore be giving up all of the rights that go along with the trial. Those rights are the right to have a trial decided by a jury, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove your guilt beyond what's called a reasonable doubt, the right to have witnesses against you appear in person at trial, the right to question any witnesses against you, the right to have the court order that your own witnesses appear in person at trial, the right to remain silent and not have your silence used against you in any way, and the right to testify at trial if you choose to testify. Do you understand all of the rights that you'll be losing or giving up that I just told you about if you plead guilty to this charge?
Mhm.
Yeah.
Yes or no?
Yes.
Okay. Do you have any questions about anything that I've said?
No.
Is there anything that you don't understand?
No.
To the offense of resisting and opposing a police officer, how do you wish to plead? Guilty or not guilty?
Or no
Not
contest.
guilty.
Or
No
not, no, hold
contest.
on, or no contest.
No guilt. I'm not guilty for none of that. I don't remember
Okay,
it.
okay. So you said you don't remember it. Does that mean you want to plead no contest?
No contest.
No, I don't want to plead guilty for
No,
it.
no, 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 no. Hold on. McCaden, no contest is one of the choices. One of the, it
No
means,
contest.
Okay, and I'm saying that I don't want to plead guilty for it, and y'all keep on trying to make me say something that I don't want to do.
okay. I'm not asking you to plead guilty or not guilty.
Caden, when you plead no contest to something, you're not admitting to it,
No
okay?
contest.
No
It just means
contest.
it just means we're not fighting it anymore to get everything else dismissed. And because we think the police report says what it says is enough, okay?
Just say no contest.
No contest.
Look at the camera.
Okay. You're saying that you don't remember it.
Mm-hmm.
Okay. All right. And are you pleading no contest because it's your choice to do that?
Mm-hmm.
Is that a yes?
Yeah.
Okay.
Yes.
All right. And other than the plea agreement, has anyone made any promises to you or threatened you in any way in order to encourage you to admit this charge?
No.
Has anyone told you the court would go easier on you if you admitted the charge?
No.
Okay. Mr. Drent, would you inquire as the factual basis, please?
Your Honor, as agreed upon, the court has a copy of the police report. I'd ask that to be admitted as Exhibit 1 and the court to use that as the factual basis for finding it for a factual basis for the plea of no contest to resisting, obstructing, opposing. Again, that is Kentwood Police Department Report 25-21493 from October 8th, 2025.
Your Honor, I have no objection to that. I've reviewed that report, and the report does contain sufficient factual information to support the plea.
All right. And Mr. Drent, do you know of any, I'm sorry, are you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor.
All right. Mr. Semkin, same question.
No, Your Honor.
And Mr. Green, as the guardian ad litem for this child, do you know of any reason why the court should not accept the plea that's just been entered by
No,
her?
Your Honor.
All right, the court is convinced that the admission is made voluntarily with understanding that there's been no undue influence, compulsion, or duress. I'm further convinced that the offense to which the juvenile is admitting was in fact committed and the admission is accurate. I further determined that the juvenile understands the nature of the charge to which she has pled no contest. The court accepts the plea given by this juvenile. Because the plea is accepted, McCaden Andre is a juvenile who comes within the provisions of the probate code. And Ms. Sweers, are you prepared to go on to disposition?
Yes, Your Honor. I would recommend that McCaden Andre be made a temporary ward of the court, that she be placed on probation in the home of her father, that she comply with the YLS assessment and case plan as determined by her probation officer, that a GPS tether be used at the discretion of her probation officer, that she meet with her probation officer as required, that she appear for all court appointments and hearings, that restitution in this matter be set at 0, that she pay the $25 crime victims' rights assessment fee, that she submit to the collection of biometric data as required by state law, that her attorney be continued, that her guardian ad litem be continued, that if recommended by the probation officer, she comply with a psychological evaluation and follow treatment recommendations, that at the probation's officer discretion, she comply with a substance use disorder evaluation and follow treatment recommendations, that she not use or possess alcohol, tobacco, vapes, or other illegal substances, that she comply with drug and alcohol testing, that she attend school as required, comply with the rules, and work to the best of her ability, and that a formal review hearing take place in approximately 90 days. Thank you.
Mr. Trent, any questions?
No questions, Your Honor.
Ms. Powell, any questions?
No questions, Your Honor. Thank you.
Mr. Simpkins, any questions?
No, Your Honor, thanks.
All right, Mr. Green, any questions on behalf
No,
of?
no questions. No questions, Your Honor.
All right, Mr. Johnson, any questions?
No, Your Honor.
All right, McCaden, do you have any questions?
No.
All right, thank you. Statements, Mr. Trent.
Your Honor, I believe the recommendations are appropriate. Ask the court to follow them.
Mr. Simpkins.
Your Honor, I also think the recommendations are appropriate. I think that she's doing very well with her father, and I agree that she should remain with him in his custody.
Ms. Powell.
Sorry, Judge, I agree.
And Mr. Green.
I concur with Mr. Simpkins and believe the placement and recommendations are appropriate. Thank you.
All right, the court finds that the recommendations are appropriate, adopts the recommendations as the court's order, and we will set a review hearing for 3 months from now. Ms. Gibson, do you have a date?
Yes, Your Honor, October 7 at 11 a.m.
Works for me.
All right, we will see you on October 7 at 11 a.m. And McCaden, keep up the good work.
Matter of Jennifer Turner versus Lindsay Ritter, file number 268254PH. This is a motion to terminate a personal protection order. The moving party is Ritter's in the courtroom. Ms. Turner is also in the courtroom. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. The court on June 25th of this year had entered a personal protection order filed by the petitioner, Ms. Turner, against Mr. Ritter. And again, that was June 25, 2026. Set to expire January 25, 2027. After the order was entered, Ms. Ritter timely filed a motion to terminate the personal protection order. And so we'll proceed in that fashion, but the understanding is under the law, it's the petitioner's burden to establish that a personal protection order should continue. And so we'll proceed in that fashion. Also, as I understand it, there was a USB that was submitted, and the court did review that as well. Apparently, it was some sort of video from inside a motor vehicle, which the court reviewed. So, Ms. Turner, why do you believe that the personal protection order should continue?
Because of that USB drive. I mean, I had an active PPO when that was presented to me, and she was following me around with that axe.
And so this is in part a motion to find her in contempt for violation of the personal protection order. You didn't file that, correct?
What do you mean?
You didn't file a motion to have her jailed. No, you did. Here it is.
I did. I took the USB drive to the Bad Axe City PD, and they told me I had to take it up to the clerk's office. When I brought it up to the clerk's office, they told me PD should handle it. But then the clerk's office helped me. They gave me the paperwork to fill out and told me what to do with that.
So the video that's on the USB drive, whose vehicle is that in?
That is out of Miss Ritter's vehicle.
Okay, okay. You reviewed that as well?
Yes,
So you believe that's a violation of the personal protection order? Why?
because she was intentionally following me.
Okay. And what do you base that upon?
That she was following me. She was behind my vehicle and then going around corners to, I don't know. I didn't even know she was there until I saw that video, so.
Okay, so on the date in question that the video was made, you were going southbound on Southport Crescent, correct? Is that correct?
Yes, that is correct.
Okay, where were you going to?
I was going from my work. I work at Independent Bank. I was off for the day, but I stopped there to see my manager. Her husband, they own Thumb Auto Glass or Thumb Glass.
Which is right here on Auto Parts.
Yep, correct.
And you were to go there?
Yep, I was going there because my windshield was cracked. I was going to pull up there. I drove through the light. I was going to pull up there, but there was another truck backing out. It was kind of raining. There were other cars parked on the side of the road. I've never been there before, so I was trying to find a driveway, and I just decided to drive around the block to wait for that guy to leave, so then I could pull in. So that's what I was doing that day.
So you drove past the driveway.
Mhm.
You turned on what street? Would it be the first street?
I'm not familiar with Bad X. Yes,
Where
I
there's
just
a
drove the
doctor's
block and
office?
turned left.
Okay, there's a doctor's office, used to be a church on.
I think so, yeah.
You turned left there.
Yep, and then just drove down and turned left and came back around.
I believe the video then shows you what I call the street that's on where the park is.
The park is, yep,
And you drove through that intersection.
yep. Just
And
up to the main road to go back to the light.
what color is the vehicle?
My vehicle is yellow.
Yellow. And then there's a third video where you're at the main traffic light where you're facing west.
Correct, because I was in the left turn lane.
And you were going back then to?
Yes, and then I pulled into Thumb Glass.
And your position is that the respondent was at the same intersection facing north.
She was, but all the videos show her going around to find my car.
Okay. Okay. And beside that issue, why do you believe the personal protection order should continue?
At the time when I submitted this, she was pretty aggressively following me around, driving around my house, beeping the horn, getting behind me at lunch, beeping the horn, flipping me off. I mean, when I came to submit this paperwork to the clerk's office the first time, she followed me here and I have witnesses. I called dispatch to let them know that she was following me. But calling 911 isn't the most convenient thing. And by the time I got someone on the phone, I was literally walking out the courthouse steps, so.
Do you know of any reason why this alleged behavior is going on?
I've never met her before in my life, but as I stated, apparently she dated one of my exes for a short time and was keeping tabs on me for quite a while.
So you don't know her from Eve in another situation? And how many times has this alleged following behavior been occurring?
It was several times. I know I noted everything in my initial statement, and then after that, there was a handful of times I caught her behind me, but I couldn't get my camera up in time, but.
Is Ritter your response?
Is it okay if I just read my opening?
Sure, absolutely.
Your Honor, my name is Lindsay Ritter and I'm the respondent in this matter. On Friday, June 19th, my former boyfriend, Kevin Brown, broke up with me. That morning, on June 20th, early in the morning, I found his truck parked outside of a home that belonged to Jennifer Turner, his ex-girlfriend. I contacted both of them that morning trying to talk things out. Clearly, I was upset. I just got cheated on. Jennifer Turner never responded to my text, nor did she answer my calls. She never sent me a text asking me not to contact her. We never had a conversation. I blocked her number the next day and I thought things subsided. Almost a week later, I got served with a personal protection order against Miss Jennifer Turner. I was absolutely appalled and in disgust with some of the statements that I was reading and knew that I wasn't going to let this woman try to take my rights away from me over hearsay and false allegations because she is upset that I found out about a situation I wasn't supposed to. The evidence that I bring forward today will show that the petitioner's statements are factually incorrect and fail to meet the legal standard for a personal protection order. Ms. Jennifer Turner has not met the required burden of proof, and the claims presented in her request lack the specific factual support needed to sustain a personal protection order. Today, I will present time cards, photo evidence from security cameras, dash cam footage from my vehicle, and a witness testimony that will contradict the petitioner's allegations. The petitioner wants you to believe I have committed a crime, but the evidence presented today will tell a different story. This case is not about assumptions or hearsay. It is about facts that will prove that there was no threat, stalking behavior, or harassment, and that this order should be dismissed.
All right. Do you have any other witnesses you wish to call?
Yeah, Kevin Brown.
Mr. Brown, would you please step up to the witness stand? Or being seated, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Please be seated. Yes, sir. Sir, would you please state your name?
My name is Kevin Brown.
Yes, go ahead. You have some questions, please step to the podium and you may ask a question.
Did you witness Ms. Ritter stalking me?
Yes.
And how so?
When we came to the courthouse here to file for PPOs at the same time, not just for yourself, but for myself and for my daughter as well. As I got here before you did, you came from the main light in town, coming through this way, pulled into your parking spot on the right-hand side of the road. Ms. Ritter was behind you. You had already sent me a message that she was behind you at the main light. She came behind you and was honking repeatedly as she went by. We came in, found out the paperwork that we found online was not the correct paperwork, so we were in there 20 minutes, 25 minutes at the county clerk's building here, so we could start filling out forms. Upon leaving, Miss Ritter was driving past us heading west, circled around the main light, came back up at the first block and stopped there. We have pictures of her stopped there at the light. She gave us a look, threw her arms up in the air and sped off and took off like that. So I can say 100% that was undoubtedly her. I'm happy with the situation. I know you have shown me videos that you have taken sitting on your porch of Miss Ritter driving by your house, turning around in the neighbor's driveway next door, so that as she had seen you sitting on the porch, waiting to video her and do that. That first night, Ms. Ritter mentioned that she did contact us early in the morning. That was 1:30, 2 o'clock in the morning, something along those lines. I don't know how she got Ms. Turner's phone number. It's not anything that I've been able to look up at any point in time. It's an unlisted phone number, but yes, she somehow had it all ready to call her at middle of the night after midnight. You sent me several pictures of her behind you. You've texted me several times that she's been behind you, is circling your work. Yes, Ms. Ritter does live 2 blocks away from the bank where Ms. Turner works, but there's no need to be circling the bank to get to her apartment complex.
You have a question?
Did I know her while you were dating her? Had we had any communication before you told me that she was doing all of this?
No.
I don't think I have any more questions. So.
Ms. Ritter?
For
questions, if you have, yes.
So So you're saying that you did see me drive past the courthouse, correct? The day that you and
Several
Mr.
times, yes.
Okay, did you ever get a subpoena to request this information, or do you have any of the video footage from me?
We have the pictures that were submitted to the court for the PPOs of you sitting outside.
I've never received.
I guess not those ones, because this was the
It
day
was
that
the
we
day
were
we
submitting.
Wait. No, I don't need to hear from petitioner. This is respondent. Go ahead, Ms. Ritter, go ahead.
So
The
you
court might have
don't,
received those because my PPO was not submitted until the next week. So I don't know.
I do not have any videos of my, or video footage or, photo evidence in any of these personal protection orders of me in front of a courthouse or my vehicle driving past a courthouse. So did you request a subpoena from the courts to get that? They do have cameras outside of the courthouse, correct?
I don't know what cameras they have. I assume they have cameras.
So did you request a subpoena to get the video footage of me driving by the courthouse that day?
No, because she had already submitted her paperwork that day.
But you are aware you can still file more paperwork after it's the first.
I'm not familiar with any of this because I don't come to court.
Okay. So you do have these photos of me outside of the courthouse,
Correct.
and you are sure it's my vehicle with my license plate?
Correct.
And it shows in those photos that my license plate clearly and me in that
No, it does
vehicle?
not show your license plate. It's the front of your vehicle.
So how are you sure that it's me in that
I
video?
witnessed you in the driver's seat.
That's all I have for questions for him right now.
Thank you. Okay, let's see if I can put this together. How do you know Ms. Ritter?
We dated for a period of time.
Okay. And obviously the dating relationship ended. When did it end?
She was at work. I sent her a message. I had dropped off all of her belongings to her apartment.
I'm just asking when.
Would have been June. I could look up the date. It was Father's Day weekend.
That's June 9th.
Father's Day weekend.
This year?
Correct. Yes, sir.
Okay. Do you have a relationship with the petitioner?
Yes.
Is it a dating relationship?
Yes, sir.
Okay. And prior to your allegations that there was some following going on at the courthouse when you filed the personal protection order, do you have any firsthand knowledge of alleged stalking or repeated contact with the petitioner by the respondent before the court date, before you appeared in the courthouse?
To file for the PPO?
Yes.
Yes, so Ms. Turner and I were in contact, and she had sent me several different videos of Ms. Ritter driving by her house, stopping and honking. We have a video, I believe all of these were turned into the Housing Police Department.
Okay.
And so.
But you don't have firsthand knowledge.
I have one firsthand occurrence when that night she came over outside, was honking in the middle of the night, sent me videos directly on Snapchat of her standing outside my vehicle outside.
Who sent videos?
Ms. Ritter sent me videos
Of what?
of herself on the road, behind my vehicle, around my vehicle, that was parked on the road next to Ms. Turner's house.
Okay.
So she sent me those where she was frustrated. She went back to Bad Axe, contacted Bad Axe Police Department, filed a report. And the officer told her no contact either way, told me no contact either way. I continued to get contact. Ms. Turner, we were still sitting at her house, and several more times throughout the night, a car that we did not see drove by honking repeatedly the exact same manner that Ms. Ritter did when she was outside Ms. Turner's house.
But you have no visual to indicate for sure that it was.
No, not that it was for sure, but the first occurrence obviously was because she sent me a video of her being there as she was sitting outside honking the horn.
Okay. Any questions in light of the courts? Yes. Any questions in light of the court's questions?
Yes.
Go ahead.
You said in this last video, I videoed myself honking the horn past Miss Turner's house. That's in the video that I sent you?
No, you sent me the video of you outside my vehicle, outside Ms. Turner's house. But at that time, you were honking repeatedly, several times before the video and after the video. Who else would be doing that at 2 o'clock in the morning?
So you've never seen me honking my horn
We looked out
or
the window and could see you doing it.
you never seen me honking my horn or seen me driving past her house at all that night?
Not those extra times that you did later.
So the first time that you were claiming that I drove past her house, you did see me outside in my vehicle?
You sent me a Snapchat video of yourself being at that premises.
I was in the video myself.
You were talking in the video. You were holding your phone, talking in the video.
So you didn't see me driving past Ms. Turner's house at all? You don't have that, you didn't record that at all?
No.
If there was a vehicle outside, neither of you guys recorded a vehicle driving past honking, blaring their horn?
No.
Did you call the police and report it afterwards?
Yes.
What police department did you call?
Ugly Police Department.
And did they come and did you write a report?
They did not come.
Why did they not come?
That's a question for them.
So you called the police and they didn't come to let you write a report?
That's a question for them. They're not regularly scheduled. We don't have-
Did either of you guys get a subpoena to have that officer come in here to state that you got a phone call?
It's the standard work line.
Can you answer the question?
I don't file for subpoenas. I don't know how the court process works like you do.
How are you thinking that I know how the court process works?
You know obviously more how it works than I do. The fact
That-
that you can ask me these
Was
questions.
this not up to you to make sure that you were ready for court, you and Ms. Turner, to make sure
I
that
am
you had
not
all your
required to
facts
be here
ready?
today. I am not required to be here today.
Why are you here then?
To make sure that everything gets on record as it should be.
That's all the questions I have.
You may step
Thank you, sir.
down. Do you have any further proofs?
There was a police report filed, with Ubley, and there was a case number. I included that in my PPO paperwork.
I didn't see that.
Okay.
I didn't see that. All right. You wish to call witnesses?
Yes.
Go ahead.
This would be for the violation of the PPO though that Ms. Turner is.
Okay.
Okay, so my witness is Miss Regine Allen. She's the manager of the Sunoco gas station in Bad Axe.
Miss, would you please step up to the witness stand?
Do you want me to explain why?
I do.
Okay.
Morning.
Morning.
Please raise your right.
Do you solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Please be seated. Miss, would you please state your name for the record?
Regine Allen, I can spell that for you.
Please.
REAGYNE-ALLEN.
Go ahead. Sure. Any questions?
Yeah. On June 30th at approximately 12:07 PM, you were working at the gas station that you worked at, correct?
Yes.
And at 12:07 PM, you said you were outside that day, right? You had somebody training inside, you were outside doing something outside at 12:07
No,
PM?
I was giving a job interview in my office. My boss was present and I had an employee at the front end of the store.
Okay. And did anyone in your store hear any honking or any noise outside at 12:07 PM?
No.
I came to you with a subpoena and we went and looked at the camera footage for facing the road from 12:05 to 12:10 PM on June 30th, correct?
Yes.
Did we ever see a yellow Bronco driving east or west from 12:05 to 12:10 on that day?
No.
And then is it true we could not get the video footage to save on a flash drive to turn into the court, so we had to have you come in today to testify?
Yes, I could not figure out a single way to get the video saved onto a flash drive at all. I'm very new at my job and my boss was not available to help provide me with the information to get the video saved.
That's all the questions I have for Sarah.
Questions?
No, thank you.
Your employee where again?
Sunoco gas station, the express stop across from Franklin on West, Your Honor?
The old Mr. Chips?
Yes.
Okay. All right, I don't have any questions. Any objection to this witness being excused? Any objection? You're excused as well.
Thank you. You guys have a good day.
You too. Further proofs?
So in this violation order that Ms. Turner turned in, it states that the PPO was signed and dated on June 25th and on June 30th at approximately 12:07 PM. She was on her lunch break. She was driving down 142 just before self-serve lumber. It says, and she heard somebody blowing their horn. She looked up to see me, apparently in her rear view mirror, swerving, blowing my horn, flipping her off, and then I quickly turned down a side road. This would not be possible if she wasn't even on that road between 12:05 to 12:10, driving east or west. So this is not a factual statement that she put in here for a violation.
Okay. Any response to that?
I don't know exactly what street she drove down. I'm not familiar with all the side streets in Bad Axe. I don't live here, but it was her. It might have been before the Sunoco, but I'm not gonna subpoena a bunch of businesses and upkeep.
But isn't the alleged violation the
It's really for the drive that I sent
USB
in.
drive here,
Yes,
right here, this part of town?
that's correct.
There's two different ones in here that. she-
Yes.
Okay. All right. What do you wish regarding the personal protection order?
That it stay in place.
Your wish.
Your Honor, this case is not about protection. It is about misuse of the legal system. The petitioner has made serious claims, but claims alone are not true. Over the course of this hearing, I've shown clear inconsistencies in their testimony, a lack of credible evidence, and motives that point toward personal gain rather than genuine fear. I respectfully ask the court to deny this petition, recognizing that the evidence, or rather the lack of it, speaks louder than any accusation.
Very well. Petitioner has a burden of persuasion to establish a motion to either terminate or modify a PPO. It's under the Pickering case. Also, burden of proof rests upon the petitioner if there's a violation. And the burden continues that way. And the court has considered the testimony, considered all the evidence. Clearly, a personal protection order was authorized. And after hearing the proofs on a motion to terminate, the court finds that there is insufficient evidence to terminate the personal protection order. Clearly, there was a reason for it to begin with. And from the testimony of Mr. Brown as well, there was even allegations regarding behaviors at the date the personal protection order was sought. So clearly, there's a sufficient basis to continue the PPO. Relative to the alleged violations, one of which was alleged to have occurred at the Mr. Chips, I call it Mr. Chips, the Sunoco on the east end of town in Bad Axe. There was testimony from Ms. Allen indicating that there was no video of the petitioner's vehicle in that area. However, court does take judicial notice that I don't know what camera angle it is, but clearly self-serve lumber is to the west of the Shell station. I guess it's Shell, Sunoco, the Sunoco gas station. So it's alleged that apparently there was beeping of the horn and all that going on. I find insufficient proof to find a violation there. The second part, though, is there were 3 videos submitted to the court on the USB drive. It appears to be either a dash cam or maybe a phone being held by someone in the vehicle, where you see the petitioner's vehicle go by, actually going down Southport Crescent. Suppose, according to her testimony, she used to go to get glass repaired at Thumb Glass. There was a vehicle backing out, so she couldn't turn into the driveway. She turns left at the block where the Dr. Roston's office is, takes that to the end, to the dead end, which I would call Park Street, but that's really not Park Street. That's, I believe, South Ansel. take South Hanselman north. The respondent, who apparently ran the video, was at the corner of Hanselman and West South Street. So it appears that, according to the video, petitioner's vehicle is in front, respondent is behind, petitioner goes past the thumb glass, turns left, respondent turns left at South Hanselman. They meet again at the intersection because you see the vehicle go by, petitioner's vehicle go by. And then there's a third video where, again, the petitioner is at the main light, and then so is the respondent. So there was a valid personal protection order at the time. And clearly, I don't know how you can chance contact each other that many times. I find a violation of the personal protection. Now, you've had your opportunity. I find a violation of the personal protection order. And it appears that this is a relationship between Mr. Brown and Ms. Ritter that's right. On the bad side, there's a bad breakup. There's now someone else in the picture, and the behaviors that are being alleged, the court finds have been established by the proper standard. Regarding a sanction in this matter, and the court has done this before, this is not a situation where someone was physically harmed, physically threatened. However, I can understand why someone would feel apprehensive, and regarding alleged harassment, which I clearly understand. And so as a result of the sanction, it's simply this, Ms. Ritter. If you see the petitioner, if she is driving down the road in her car, don't follow her. Don't.
I went the other way in that video.
Don't associate with her. But there were 3 encounters.
I went the opposite way each time.
I understand.
And went to the sheriff's department
Again,
after.
you've had the opportunity to speak.
Yes, sir.
I found a violation of the personal protection order. I'm not going to issue a sanction. But what I'm telling you is, drop this relationship.
Absolutely. I already have.
He is clearly in a different relationship. Look elsewhere. On the same side, I don't want any fueling of the fire here by anyone. Just mind what the personal protection order calls for. Stay away from each other, and we'll leave it at that. That's all. I wish you all the best. Personal protection order remains. No other sanctions will be imposed. You're free to go.
Thank you.
You two go first. We're on the record matter, people of the state of Michigan versus Christopher Allen Smith. There are 2 files. 267488 FH, time and date set for arraignment, as well as people of the state of Michigan versus Christopher Allen Smith, file number 257373 FH. That's a motion to revoke bond. Attorney Michelle R. Siv appears on behalf of the defendant. She appears via the Zoom application. The defendant is not in the courtroom. People are represented by Chief Assistant Prosecuting Attorney David J. Wallace. The court had a brief conference with both counsel off the record, and the court was advised that the defendant is back in the hospital. Ms. Siv, do you wish to place that on the record?
Yeah, so I had conversations with Mr. Smith's significant other, and she had advised me that Mr. Smith is currently at the emergency room at McLaren in Bad Axe. He was having like an anxiety attack and issues with breathing properly and whatnot. So as a result, they were able to get to the emergency room. I'm not sure how the court would want to proceed. I would ask for the court to consider an adjournment at this time to give Mr. Smith the opportunity to, do what he needs to do with to address his health issues, and then to address this the motion to have his bond revoked when he can be present.
This would be the second adjournment, correct?
First adjournment for this particular hearing for this particular motion to have his bond revoked. It would be the first for this one. This did happen a little while back on a different motion that had to do with his bond, but I believe that could have been the first issue.
Yes, Your Honor. As leading to, this is the third time we brought this motion because it's the third violation. The first time was back in March 10th, March 9th, we had the hearing and it was admitted to at that point in time. Then June 1st, we filed this second motion for violation. And at that point in time, that's when the defendant admitted himself. I say admit, he did not admit himself. He went to the ER and the court in fact asked for documentation or something to say, okay, show us what's going on. There was a picture was given. I don't believe the court ever received any documentation of that. And then now we have a third violation, and again, not testing is what is required. The court made it clear to him last time, you have to test. And now he has gone back to the ER for apparently similar concerns and complaints as to the last time that he was there on June 1st. Your Honor, it may not be a game, but it sure feels like a game here going on. So trying to delay whatever's going on and not be here in court when he's supposed to be here. We think that the only appropriate response, Your Honor, is a bench warrant, not to adjourn this matter. And that as soon as he's released from the hospital, that he be placed into the Huron County Jail. Any other comments?
Well, Your Honor, when a client or someone close to the client comes to me and there's a medical issue regarding his actual health, I think that it is important for that person to address that issue. I don't think I'm the one to advise to not follow medical advice or anything of that nature, but I just think the court should look at it that way as well. And again, to just adjourn the matter so that way he can get whatever proper type of medical help he needs. So I don't think that it would be fair for the court to issue a bench warrant when he knows that he's supposed to be here. He's aware of it. I'm advised of where he currently is. It's not like he's trying to hide from me or anything like that. He's either him or his spouse have been in contact with me. So.
Thank you. All right, this is the second time. And this is the third allegation regarding an alleged bond violation. And the court was very clear about requiring testing and following the conditions of bond. If the defendant does not appear in the courtroom by noon today, the court will adjourn the proceedings to tomorrow morning at 9 a.m. If he fails to appear tomorrow at 9, the court will address it at that time. But the court requires not only a photograph, the court requires some record from the hospital to indicate that he is in the hospital for treatment. I'm not doubting Ms. Siv. It's just she gets the information from her client or her client's significant other. So I'm not doubting Ms. Siv's comments. But this is the second time, and it just seems to be so coincidental with a bond violation hearing. So if he fails to appear by noon today, he is to appear tomorrow morning at 9 a.m. Ms. Siv, are you available tomorrow morning at 9?
I can be, Your Honor. I just wanted the record to reflect that the last time he did provide some documentation, and I let the court know that I had that documentation, that he was in fact in the emergency room. I did not submit it, but I did put on the record that I received it. So I just wanted the court to be aware of that.
So noted. So noted. We'll adjourn the matters. People of the State of Michigan versus Michael Shannon Miller, 247208FH. Time and date set for final pretrial. The defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Tim J. Rakowski. The court is in receipt of an advice of rights form. Does the defendant wish to change his plea?
Yes, Your Honor.
Thank you. Mr. Miller, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Rakowski, would you please state the terms of the plea offer on the record?
Yes, Your Honor. The terms of the offer are that Mr. Miller, they plead no contest to 2 counts of CSC third. In exchange for that, the people agreed to dismiss the remaining counts of criminal sexual conduct charge.
Ms. Weisenbach, is that your understanding?
Yes, Your Honor.
Mr. Miller, is that your understanding?
Yes.
And you wish to accept that offer?
Yes.
Are there any other terms to the plea offer that we've not covered on this record? Weisenbach, do you agree?
I agree.
I agree, Your Honor.
Mr. Miller, are you on any term of probation or parole?
I'm on probation. That's what we're for.
Have you had sufficient time to speak to Ms. Weisenbach?
Yes.
You need any additional time to speak?
No.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No.
You have a clear mind?
Yes.
Pursuant to the plea offer, you'd be pleading to 2 counts of criminal sexual conduct in the 3rd degree. Those are both felonies carrying a maximum prison sentence of up to 15 years. Mandatory testing would be done. And this would be a tier 3. I believe this would be lifetime registration. You understand that, sir?
Yes.
All right. Understanding that, then, Ms. Weisenbach, how does client plead to the 2 counts of criminal sexual conduct, 3rd degree, during the time frame of September 1, 2024 through October 20, 2024 in Ubley Front?
No contest.
Is it no contest?
Yes.
Reason for the no contest, Ms. Weisenbach.
Civil liability, Your Honor.
Any objection, Mr. Rakowski?
We have no objection.
Proper basis to proceed. The court is in receipt of an advice of rights form, has a signature on it, a printed name of Michael Miller. It's actually dated July 30th. Mr. Miller, do you recall signing a document like that?
Yes.
Now, before signing it, did you read this document over?
Yes.
Did you also go over it with Ms. Weisenbach?
Yes.
You understand the rights contained on the form?
Yes.
By pleading no contest, you're giving up those rights.
Yes.
You will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. No contest pleas tantamount to you admitting your guilt, and all that remains after today will be free to be sentenced. Understand that? If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you to plead in this?
No.
Understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you and impose a sentence. Has anyone promised the court would be easy on you?
No.
Has anyone threatened you to enter this case?
No.
Your own free choice.
Yes.
Court costs are due and payable at time of sentencing unless there's good cause. You understand that?
Yes.
And you're subject to a 20% late penalty for any unpaid court cost due 56 days following your conviction and sentence. Understand?
Yes.
Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal for the conviction and sentence pursuant to these pleas will be by application for leave to appeal and not by right. Miller, any question regarding any of your rights?
No.
Questions of Ms. White? Court is in receipt of People's Proposed Exhibit number 1, which appears to be Ubley Police Department Incident Report 24-276. Ms. Weisenbach, any objection for doing this, accepting it for purposes of factual basis?
No.
Equals 1 is accepted, the court will review it. Rakowski, you aware of any promises, threats, or inducements other than what's been disclosed?
No, Your Honor.
Ms. Weiss? No. Has the court complied with the court rule concerning?
The court has.
Ms. Weiss?
Yes.
Mr. Miller, there's no agreement made by this court concerning the plea and what the final sentence. Is that accurate?
Yes.
Ms. Weiss?
Yes.
Yes, Your Honor.
Court will accept the pleas are done freely, voluntary, and understanding. A sufficient factual basis has been provided in review of incident report 24-276, where the defendant admits to the allegations contained within the information. We will schedule sentencing for October 5, 2026 is sentencing at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence report. And that pre-sentence report must be provided to the court no later than 2 days from sentencing. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from, let me back up. The report is to be provided within 2 days of sentencing. The guidelines will be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. The defendant must appear in the courtroom at time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set at $10,000, 10%. Mr. Rakowski, your position on bond.
We have no objection to continuing bond.
Ms. Weiss?
Ask the court to continue bond.
Bond will continue in this matter. However, the court will require that SORA requirements be complied with. Order that. Versus Tamara Ann Denny, file number 267439FH. Time of day set for sentencing. Ms. Denny is present, represented by Attorney Elizabeth Weisenbach. People are represented by Prosecuting Attorney J. On June 8th of this year, the defendant entered a plea to possession of methamphetamine. Ms. Karen Eberlin prepared the pre-sentence report dated July 6th. Ms. Weisenbach, have you and your client had the opportunity to review the report?
Yes, Your Honor.
Are there any additions, deletions?
Update. Page 10 indicates that my client was taking medications. The update is that she does not have those any longer. Strike that one.
So noted.
Thank you. No other corrections or changes.
Denny, do you agree with that? Mr. Rakowski, any objection to the report?
No, Your Honor.
Any objection?
No, Your Honor.
Any objection to scoring the guidelines?
No, Your Honor.
Anything you'd like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. Two things with regards to the PSI that weren't really corrections or whatever. With regard to 7411, my client had told her first attorney, now me as her second attorney, that she'd had a prior in Lapeer, and we also appreciated the prosecutor's offer. And at the last minute, I did reluctantly submit the petition for the 7411, but we know that she does not qualify. So I was following the regards to that, but it is what it is. So with that being said, she is being recommended a probationary period of time, and her boyfriend, the co-defendant, is going through recovery court. With that being said, we believe that she will do well on her own through the probationary period because, as the court also received pages of AA and NA Peer 360 reports, also letters that she had received that I submitted to the court, just pages and pages. And look at what I have today. I have more pages and pages of the effort that she put in. Behind us today, and always behind her, is her support group. So we've got folks from Peer 360, co-defendant boyfriend, as well as her actual sponsor is here today to support her. So behind her at all times and with her, helping her stay recovered. So that keychain go. I also have for you as a visual, we've got the 6 months NA, they give out keychains, AA gives out coins. So this says clean and serene for 6 months. And I told her that I would probably pull off the first one, probably not the second one so well. That requires someone to be serene. So I am in a good spirit because I have an excellent client sitting next to me here, standing next to me here. She's got a little bit to tell you about herself, but when things got tough, she should have made a better choice. She knows that. She knows that. We have reviewed all of this, the medications she doesn't need anymore. She missed a couple of appointments. It's in here that she had a little bit of a trip up getting to counseling, but that was because she was working. She's gainfully employed, and she's looking at management at Taco Bell. Just as soon as this court case causes this to be squashed, then she'll be able to apply for management at Taco Bell. So with that being said, I have in front of me and beside me, with her support behind her, candidate for excellent probation. We would ask the court to follow this recommendation, especially with regards to the jail being held in abeyance, because she is doing so well. So I'd ask the court to follow the recommendation as is. And then she does have something for you.
David, anything you'd like to say?
I want to apologize for the action. Sorry. I was going through a lot when I did what I did, and instead of reaching out like I should have, which I learned now, I called the whole incident. I called 911 on myself. I wanted help. I wanted out of that lifestyle. And through 360 and NA and AA, I've learned to identify my triggers and learn how to work with them instead of let them work against me. I've gotten to have a better relationship with my kids and my family. I've gotten into recovery. I can't express the regrets I have for what I did, but I can vouch for what I'm going to do from here on forward and how I'm going to make my life a better life, not just for myself, but for my family and my kids. I've been partaking in community service with your 360. I actually got to go to the fairgrounds as a kid. I always wanted to work in the Lions tent. I don't know, it was something little, but through helping with the sobriety court, they did an event out there to do community service, cleaning up the fairgrounds. I got to help with that. I really enjoyed it. It actually gave purpose to my life, being able to do those things.
Skorkowski, on behalf of
Your Honor, the pre-sentence investigation is accurate. We ask you fashion a fair and just sentence.
Steady, you have a lifelong battle you're going to have to take care of. This is not where you can just get it done in 6 months, or even 5 years or 6 years. It's not going to happen. It's always going to be there. And as a result of that, you need to take steps to put you in a better situation. You've been doing so. I highly respect the folks who have ever since learned of the program. And it's a wonderful program that holds people accountable, but on the flip side, provides an alternative for individuals who want to enjoy life as well. Whether it be community activities, it could be going to like golf, it could be just about anything, who knows? But clearly, it's an alternative program that gives individuals like you an opportunity, so in some ways, to spread your wings and be human, frankly, and that's a good thing. But the struggle will always continue. The substance that is involved is very addictive poison, and I've always, I shouldn't say always, but I've attempted to ask people who are before the court facing this type of charge involving methamphetamine to look in to see what the ingredients are. Falling. See exactly what's inside that substance. So if you want a scared straight program, there's one for you too. Your 360 is a wonderful program. You are not eligible for 7411 status because of the prior conviction, but you're taking positive steps to move forward in light of the circumstances. So will be the sentence of this court that you placed on a term of probation for a period of 18 months. Conditions of probation include the standard conditions not to violate any criminal law of the government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent monthly for such times and places the agent is required, No possession or use of alcohol or other intoxicants. You cannot enter bars or other places where they serve it. We're to comply with all the requirements of alcohol and drug testing and follow all their rules. Obviously, you must not use or possess any controlled substance not duly prescribed to you. Can't be around anyone that possesses those items, nor can you possess or be around anyone that possesses those. You are to complete substance abuse assessment, outpatient or residential substance abuse treatment when referred by the agent. You are to complete other recommended treatment following assessment by a qualified community-based service provider. You are to waive confidentiality and allow any treatment program to provides that assistance to provide that information to the probation officer. No assault of abusive, threatening, or intimidating behavior. No verbal, written, electronic, or physical contact without permission of the agent with anyone housed within an MDOC facility, nor are you to be around anyone that's engaging in a behavior that constitutes a violation of any criminal law of any government. You are not to use any object as a weapon. You cannot have under your control or area control. You cannot possess, use a weapon of any type. Not even possess an imitation one. You can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the first business day following your placement on probation. Comply with all written and verbal orders of the agent. You are to allow the agent in your residence at any time for probation supervision where you're subject to a search of the person's property, including but not limited to your home, vehicle, or computer without the need of a warrant if the agent has reason to cause you of items that violate the terms and conditions of probation. 24-hour rule will apply regarding any arrest, police contact, loss of employment, or change of residence. You are employed, and you are to continue to maintain legitimate employment minimum of 30 hours per week unless engaged in programs by the department. Crime victims assessment of $130, probation supervision $30 per month regular, electronic. Court cost of $200 payable at the rate of $20 a month. A fine of $200 payable at the rate of $20 a month. These are waived. State cost of $68 will be ordered. Probation is authorized and empowered under statute to effect your apprehension and confinement of up to 72 hours on reasonable cause you have violated the terms of probation. If referred, you must successfully complete any PA 511 programming based on eligibility. Finally, you shall serve 270 days in the county jail, credit for 1 day previously served. The 269 remaining days will be held in advance, which means that it can comply with the terms and conditions of probation and continue to toe the line here relative to not only these rules, but your overall health relative to use of substances. You won't have to see another county jail cell again. That's up to you. You need to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, court will assign counsel for inappropriate expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Any good luck to you.
Quiet location and unmute until your case is called. When your case is called, please turn on your video and unmute yourself. We are creating a court record. There is some lag time between speakers, so it is important that you speak slowly and clearly. Do not interrupt when others are speaking. Wait for a moment or two before responding to avoid talking over each other. Please have a pen and paper ready as you may be given a phone number to call at the end of your hearing. Please note all participants must appear by video and rename your device to properly identify yourself. Thank you. Your hearing should be called shortly.
Good morning, everyone. Welcome to the 87A District Court. I'm Judge Heslink. We'll get started on the criminal docket with the probation violation matters. First matter this morning is State of Michigan versus Mark Dingman. There are two files for that. First is 24-42558-SD set for a probation violation hearing. The second is Mark Dingman, file 26-44554-ST set for a bench warrant arraignment. I do see Mr. Dingman is with us. Mr. Dingman, do you have an attorney?
Your Honor, I do not. I was unable to secure any attorney. I did call, let's see, I'm sorry, Your Honor. I did call Gary Gillow, and I have not received any call back or any email back as well. So I was unable to secure any lawyer, sir. So if we have to proceed today, I understand.
Mr. Gilow's office is for court-appointed counsel. When did you call him?
I called him yesterday and this morning, Your Honor.
Kind of wait until the last minute. When did you find out that you weren't able to retain your own attorney?
About 4 days ago. I didn't have the money to get one, and then I saw on the paperwork I could call Gary, so I did. And yeah, I was fine. I just rushed. I didn't notice that you put Gary's number on the second notice to appear, and so I called him yesterday, and I called him again this morning, and no answer.
All right. Well, thank you for trying anyway. Are you working full time at this point?
Yes, Your Honor. Actually, I have 2 full-time jobs. I work at Porterhouse 6 days a week, usually at 4 till about 10, 11 o'clock at night. And then I'm opening up Second Street Pub right now, which is the old Bearded Dog. Yes, Becker opening up a new restaurant as well.
Under those circumstances, it's likely that you won't qualify for a court-appointed attorney. You have to be indigent, which means that you typically would fall below the poverty line. And if you're working 2 jobs, you probably aren't going to do that. I'll continue to let you call Mr. Gilo's office if you wish. Do you want to try to do that and postpone the probation violation, or would you rather proceed on your own today?
I would not mind to be able to call Gary for that probation violation.
All right.
The more help I can get them. I do want to get this put behind me though. I want to get moved on with the rest of my life. I found out I did have a baby on the way. I'm trying to get a house at the moment. I'm, trying to get my life going, sir. That last situation in 2024, and don't ever want to drink again. And I just want to be a good man.
All right. I'm going to have my staff contact Mr. Gilo's office as well. Is there a phone number that we can use to give Mr. Gilo's office so they can call you?
Yes, Your Honor. 231-340-5921.
All right. I have that. And I'll have my staff contact Mr. Gilo's office and see if you qualify for court-appointed counsel on the probation violation matter.
Thank you.
On the other case that I have in front of you, there's a charge of driving with license suspended. I'm going to arraign you on that, but it looks like you failed to appear on that matter both on May the 18th and June 1st.
Oh, yes, I am. For one, sorry about that, Your Honor. 2, I thought both cases would be one, I guess. When this whole thing kicked off, it kicked off because I did get pulled over. I was unaware that I had a warrant. I was unaware. I thought I was done with probation. I thought I was done with everything, Your Honor. That getting pulled over is kind of what kicked everything off. And I hopefully I had a suspended license.
All right. Well, you showed up today. You showed up in the past for the probation violation. It was just unusual that you didn't show up for this twice. You didn't show up for the new case. So I'm going to withdraw the bench warrant.
Thank you, Your Honor.
But any further failures will have another bench warrant, and I'm just going to leave you in jail for a while to make my point. You understand?
Of course, Your Honor.
All right. So here's what I'm going to do on this. Then I am going to arraign you. So I'm going to let me make my notes, and then I'll tell you what you're charged with, tell you what your rights are, and I'm probably at that point simply going to give you an opportunity to find out if Mr. Gilo's office can appoint an attorney for you on this case as well. But at least we'll have the process started at that point. So let me make a couple notes, and then I'll talk to you in just a minute.
Thank you.
All right, Mr. Dingman, the charge against you reads as follows. It says that on or about May 1st of 2026, within Bagley Township of Otsego County, specifically on Chris Road near Polar Trail, that you did drive with your license suspended and that you operated a motor vehicle on a public highway while your license was either suspended, revoked, or denied. That is a misdemeanor offense that has a maximum penalty of 93 days and or a $500 fine. You understand the name of the offense that you've been charged with?
Yes, Your Honor.
You understand the maximum possible penalty?
Yes, Your Honor.
As to that charge, you have the right to plead guilty, not guilty, or no contest. You have the right to have a trial by a judge or a jury. And you have the right to be represented by an attorney. If you cannot afford an attorney will be appointed for you. And we're going to give you an opportunity to have that looked at in just a few minutes. Let me explain your trial rights in a little more detail. You have the right to see, hear, and question all the witnesses against you. You have the right to get a subpoena for your witnesses to appear and testify, to require them to testify on your behalf. You also have the right to testify, or you can choose to remain silent and not have that silence used against you. At a trial, you'd be presumed innocent, so proven guilty beyond a reasonable doubt, and that burden of proof will remain with the prosecutor at all times. Finally, at a trial, you have the right to automatically appeal, but if you enter a plea at any time, you'd be limited to asking for permission to appeal, and that might not be granted. You understand all the rights I've just given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
All right. What I'm going to do then is make a referral to Mr. Gilo's office on this matter as well, and we'll see if you qualify. Like I said before, you may not simply because you're working 2 jobs, but we'll at least give you the opportunity to figure that out for sure. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights.
Thank you, sir.
Yes, we can set up pre-trial jury status conference.
All right. I'm going to set a new date on both of these to kind of make sure we don't lose track of them.
So we'll do the jury status conference on September 3rd at 9 a.m.
All right. I'll see you back here on September the 3rd at 9 a.m. Do you have any conflicts with that?
No, Your Honor.
All right. September the 3rd is a Thursday, first Thursday in September. So I'll see you then.
Yes, sir.
Keep trying to get a hold of Mr. Gilo's office. My office will also make contact with him and give him your phone number, and we'll go from there. All right. Good luck, sir. I'll talk to you in about a month.
Thank you, sir.
Next case is State of Michigan versus Jamail Kelly, file 24-43238-SD. We have Mr. Kelly with us.
He's not here.
Ms. Parker, excuse me, Ms. Hill, have you had any contact from Mr. Kelly?
I've had voicemails from him, Your Honor, but I returned them with no answer, so no.
All right. Looks like he's failed to appear a number of times in the past. Got a failure to appear in order to show cause in April of this year, a bench warrant later in April of this year, and then another failure to appear bench warrant in June of this year. He posted anything on his bonds, or those still outstanding?
I believe he posted on the bonds with a bondsman.
No, he just wasted that money. We're going to issue another bond, bench warrant for failure to appear today. Last bond was 2,000. This one's going to be 3,000. All right. The next matter is State of Michigan versus Travis Stollard. 3 files. First is 25-44189-SM, set for probation violation. Next is 25-43783-SM, also set for probation violation. And the third file is 25-44083-FY, also set for probation violation. And you see Mr. Stollard is here. Mr. Dick, I believe this is your matter as well.
Yes, James Dick on behalf of Mr. Stollard on all 3 files, Your Honor.
All right. Looks like we previously told him what his charges were on probation violations, and he asked for court-appointed counsel. I believe that's when you were appointed, Mr. Dick. So how does your client wish to proceed on these probation violations?
Your Honor, we unfortunately don't have a resolution to both allegations. However, if one of them were potentially dismissed, he would be willing to take responsibility for the violation of contact with the prohibited party. The other one is the contested issue. So if we,
sorry. So he wants to contest the consuming alcohol, but he's willing to plead to the no contact order?
Yes, Your Honor.
Ms. Hill, is that acceptable?
That's fine, Your Honor.
All right. I will go along with that, Mr. Dick. Mr. Stollard, you've heard what your attorney has said. Is that what you want to do?
Yes, Your Honor.
All right. I'm going to ask you to raise your right hand so I can take some testimony from you. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. You've been charged with a probation violation of breaking a no contact order by contacting Natasha Bunning on 6/16/26. Do you understand that?
Yes.
The recommendation, and it may change given the fact that there's a change in the offer, but the recommendation is that you serve 5 days in jail. Do you understand that?
I do.
If you wish to have a contested hearing and not enter a plea, you would have the right to have a hearing in front of me as the judge. You don't have the right to have a jury trial. You understand that?
I do.
All right, let me explain all of the other things that go along with giving up that hearing. At a hearing, you could see, hear, and question all the witnesses. You'd have the right to have your attorney, Mr. Dick, represent you at that hearing. At the hearing, you could have witnesses appear and testify on your behalf and get a subpoena from the court to require them to appear and testify. At a hearing, you could testify, or you could choose to remain silent, and whichever you did, the silence could not be used against you. At the hearing, you'd be presumed innocent until proven guilty beyond a reasonable doubt by the probation department. The burden would remain with the probation department at all times. Finally, you'd have a right to automatically appeal. If you enter a plea today, you'd be giving up all of those hearing rights that I just described. You understand all of that?
I do.
Knowing that, is it still your desire to enter into this plea agreement today?
Yes, please.
All right. Has anybody promised you anything other than what's been stated here on the record today?
No, Your Honor.
Has anybody threatened you in any way to get you to do this?
No.
So you're doing this of your own free choice and free will?
Yes.
All right. Is it true then that you have a probation order that says that you are to have no contact with Natasha Bunning?
Yes.
And is it also true that on June 16th of this year that you had contact with Natasha Bunning in violation of your probation order?
Yes.
All right. Mr. Dick, do you have any other factual basis questions?
No, Your Honor, I believe that satisfies the requirements.
All right. Are you aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
All right, Mr. Stollard, I will find that you've made a proper plea, that you made that plea knowingly, intelligently, and voluntarily, and that you have in fact violated your probation by having contact with Natasha Bunning on or about June 16th of 2026 in violation of your probation order. Ms. Hill, given the change in the plea, is there any change to your recommendation?
No, Your Honor, and I leave the jail days up to you.
All right, thank you. Mr. Dick, any allocution on your behalf?
Your Honor, Mr. Stallard, well, he's here today because he's admitting a judgment, and he is aware that he's not supposed to have contact with Ms. Bunting. That being said, Mr. Stallard has been setting things up to be able to move out of state, specifically to Utah, to kind of make sure that this kind of a thing does not occur in the future. However, under the circumstances, we would ask that the court considers the adopting the recommendation at least and to perhaps extend the probationary period, but allow perhaps a lesser amount of jail time, or provide for a lesser amount of jail time if the court's going to require it. If possible, perhaps allow Mr. Stallard to be able to work during the day and turn himself in the evening. He has been working on everything else, trying to get the rest of his life in order. He does get his driver's license back in December. So he on the otherwise on the right track with things. This was the only issue that I'm aware of, Your Honor, that he's had thus far.
Thank you, Mr. Dick. Mr. Bunning Mr. Stollard, is there anything else that you want to say on your own behalf?
I knew I did wrong and it was a one-time thing. I'm trying really hard to take care of everything. I know it's not going to happen again. I'm trying.
Help me understand why you did it to begin with.
It was a free concert. They had extra tickets and I really wanted to go. That was it.
So what stopped you from going by yourself?
I didn't pay for nothing. I didn't pay for no tickets or the ride. I would have never have gone if I had to pay.
Okay, so you had free tickets. Why didn't you go by yourself?
No, I didn't have the tickets. My buddy did, and his girlfriend worked with Natasha. I didn't buy them.
So you're telling me that she came and picked you up and took you to a free concert?
Yeah, they did.
And you knew that she was coming along for the ride?
Yes, and I still went.
I have a picture of you on Snapchat with her, and you're riding in the car in the back seat, right? And it looks like they're both passed out and you're laughing.
I was sober the whole time.
I'm not saying that you weren't. I'm just saying that it looks like they were passed out. This doesn't look like you were just got picked up by somebody and happened to go along for a ride to a concert. Are you minimizing what you did here to me? Or are you telling me what really happened?
That is really what happened. They picked me up. We went down there for that concert and then came back that night. That's why I had taken that random drug test the following morning.
So you're telling me that a free concert is worth 5 days in jail?
No, not at all.
That's what it sounds like.
No.
Well, then why
I
would you
wish-
go to the concert when you know that I can throw you in jail for violating probation?
I wish I wouldn't have.
Well, I get it now, you wish you wouldn't have, but why at the time would you make that decision?
I don't know. I really wanted to see them.
See, there's the problem. How old are you? 44, and you still haven't learned how to control your impulses? You know
For the
that a
most
judge
part.
can throw you in jail for violating your probation, but some girl comes along with a concert ticket and you're going to go and hope that you don't get caught so you don't get thrown in jail. That's what you're telling me.
That's what I did.
Yeah, that's exactly what you did. And now you're in front of me saying, it was her fault. She had the ticket. She asked me to go. She picked me up.
No, she didn't, but I did go knowing she was going.
How is what you just said different than what I said?
She didn't pick me up. She didn't drive. That's all I'm trying to say. I'm sorry.
You know what a distinction without a difference is?
No.
Here's my problem. You haven't learned anything. You're 44 years old and you still haven't figured out how to say no when you know it's going to get you in trouble. How do I change that? How do I make you grow up?
I am now.
You are now what?
That was a one-time thing that I plan on never doing again. That's why I'm trying to move. I've got a good job off.
How is moving going to change anything? Mr. Stollard, how is moving going to change anything?
It won't. I won't be around to be impulsive. I'll be working a lot too.
I'm glad to hear that you'll be working a lot, but the move isn't going to change you. That's the problem. You're 44 and you don't know how to say no. I'm looking at 3 different files: domestic violence and child abuse, resisting and obstructing the police, and domestic violence and operating while intoxicated, all in 2025. So I can't buy your story that this is just a one-time issue problem. The probation violation was one time, but you've got so much outstanding that I can't just say nothing's going to happen. So my sentence is 5 days in jail. When are you going to Utah? When are you planning on? When would you like to go to Utah?
I was trying to get all this taken care of first.
Your
You don't
Honor,
have-
he wouldn't be able to go to Utah until his work camp days are done. He has not completed them.
How much more has he got to do?
I believe he still has 6.
When would he normally be off probation?
The 25-44189 case last month on the 29th. He has until January 29th for the 43783 case. And then the last case he has until October 29th.
You got a while yet, Mr. Stoller, before you can go anywhere.
Yes.
When do you want to report to the jail?
Can I start Monday or Saturday? I was gonna do work camp on Friday.
Yep, August 8th, Saturday, August 8th at 6 p.m. That'll let you get your work camp in on Friday and have a day on Saturday to do whatever you need to do around the house before you report.
Are we going to extend the one case so it follows the other ones?
No, let's close that one.
Okay.
Discharge him unsuccessfully from that one, and I still have him on the other 2.
Okay.
Do you have any questions, Mr. Stollard?
Oh, you're on.
6 p.m. Saturday, August 8th at the Otsego County Jail. If you're not there, a bench warrant will issue to pick you up.
I'll be there.
Good luck, sir.
Thank you.
State of Michigan versus Nathan Childs, file 23-42221-SD, set for probation violation. We have Mr. Childs with us.
He's coming on now.
All right, I do see Mr. Childs is with us. Looks like we arraigned Mr. Childs on July the 9th. He asked for court-appointed counsel, and then I said he looks like he didn't qualify for that, and he asked for some time to get his own attorney. Mr. Childs, have you done that?
I've decided to proceed without one.
All right. If you change your mind at any time, let me know. How do you want to proceed then? Let me remind you what you're charged with. The allegation against you is that you failed to report for March, complete your work camp within 30 days, provide proof of substance abuse counseling, and complete the highway safety class with the victim impact panel and pay your fines and costs. In addition, it's also alleged that you've absconded from probation. That means you've been gone for more than 60 days. The recommendations are that you serve 30 days in jail and be discharged unsuccessfully. You have the right to have a hearing on that in front of me as the judge, or you have the right to plead to that. Which would you like to do?
I would like to plead.
All right. If you plead, you'd be giving up your right to have a hearing and all the procedural protections that occur at a hearing. Do you understand that?
Yes, sir.
Included in your rights at a hearing would be the right to be represented by an attorney, the right to have the hearing in front of me as the judge, the right to see, hear, and question all the witnesses, the right to have witnesses appear on your own behalf and get a subpoena from the court to require those witnesses to appear and testify. In addition, you'd be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the probation department at all times. Finally, you'd also be giving up your right to appeal. You understand all those rights that you'd be giving up?
Yes, sir.
Knowing all that, do you still wish to enter a plea to this probation violation?
Yes, sir.
Would you raise your right hand so I can swear you in then, so I can take some testimony? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down, sir. Has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes.
All right. The allegations against you are what I just mentioned. I'm going to go through them in detail, so I'm going to break them up a little bit and ask you each section whether or not you did that, just to make sure we're clear. So the first allegation is that you failed to report to probation for the month of March. Is that true?
Yes, sir.
The next allegation is that you failed to complete your work camp requirements within 30 days. Is that true?
Yes, sir.
Did you also fail to provide proof of substance abuse counseling?
Yes, sir.
Did you also fail to complete your highway safety class with the victim impact panel?
Yes, sir.
And also, did you fail to pay your fines and costs?
Yes, sir.
Finally, did you abscond from probation? That is, were you gone for more than 60 days without reporting to your probation officer?
Yes, sir, I was.
All right. I'm going to give you an opportunity now to explain or give me any other information that you want me to have about the reasons why you did all of those things.
Particularly at the moment, I had a weird living situation and I was not able to actually pay for the classes that I was supposed to take. I'm currently paying a lot of child support, trying to catch that up right now. So it was more or less like a money thing.
Well, that explains part of it, but it doesn't say why you failed to appear and failed to complete your work camp, right?
One of the particular things, and I realized it was my fault. I had wrote down the wrong day that I was supposed to report. And then once I actually realized it, I kind of just panicked. Is pretty much how that worked. I know I just made things worse for myself, but yeah.
And then you didn't go to your highway safety class or your victim impact panel. What was going on with that?
Again, that was a money issue. I was currently paying quite a bit of rent, and like I said, I'm trying to catch my child support up. So that takes quite a bit of my check every week. So I was actually trying to get on health insurance to help me pay for the class as well, but that didn't wind up turning out for me. So,
all right, Ms. Hill, is there any change? No, I appreciate that, Mr. Childs. Thank you, Ms. Hill. Any change in your recommendations or any additional information that you want me to have?
No, Your Honor.
Mr. Childs, you heard the recommendation is that you serve 30 days in jail and be discharged unsuccessfully. What do you have to say about that?
I agree with the court's decision. And like I said, I realized I made a mistake and made this a lot harder than it should have been.
Called in and said, hey, I'm working hard to pay my child support off. Can I have a little bit more time to deal with my probation issues? We probably would have worked with you. If you'd have said, hey, I'm trying to get some insurance on this, can you give me a little bit more time to get into my classes? We would have worked with you on that. If you'd have said, hey, I've freaked out, I got panicked there for a minute, and I apologize for missing a month of my probation, but now I'm ready to contact you, I'm ready to do what I need to do, we would have worked with you. But you didn't do any of those things.
I do realize that. Yes, Your Honor.
All right, Mr. Childs, here's what I'm going to do. It appears to me that you are taking responsibility for your actions now. So I'm going to cut in half the penalty because I think attitude is half the problem, half the gain for you. And you've come at least that far where you recognize, hey, I did something wrong. If you were just blowing me off, then 30 days is an appropriate thing. But you're here today. You're taking responsibility for that. Hopefully that means in the future, number one, you don't get on probation, but you make better decisions because you're taking responsibility for things and you're not getting yourself in trouble. So I am going to put you in jail, but for only half the time that is recommended because of your good attitude. So
thank you.
The sentence for that is 15 days in jail. When would you like to report to the jail? When would it be easiest for you in the next couple of days?
Would it be possible if I could come in on Monday because my work week ends on Sunday? And that way I can at least get the full work pay in?
Yep. So Monday is August the 10th. I'll give you until 6 p.m. on August the 10th. And you can still get credit for that as a full day in the jail if you report by 6 p.m.
Thank you very much, Your Honor.
So August 10th at 6 p.m. at the Otsego County Jail for 15 days. And then we will unsuccessfully discharge you from probation, so you will be done with us at that point as well.
Thank you.
Ms. Hill, does he still owe fines and costs?
He does. There was a bond posted, but he wasn't the one to post it. So I don't know if it can be applied.
All right. Mr. Childs, what she's talking about there is if you didn't post the bond, it can't be applied to your fines and costs unless the person who posted it agrees to that. So you may want to check into that, see whether or not they want their bond money back or if they want to allow it to be applied to your fines and costs. Even though you're unsuccessfully discharged from probation, you will still owe the fines and costs. So you don't have to do any of the other conditions, but the fines and costs are still a due and owing thing. And that can be enforced in the future by contempt of court, meaning you could go back to jail if you don't pay your fines and costs within a reasonable amount of time. Do you understand what I just said?
Yes, sir.
Good luck to you, sir.
All right, thank you.
That's all for today. Next matter is the State of Michigan versus Stephen Behrens, file 25-43915-SD. We have Mr. Behrens with us.
I haven't seen him, Your Honor.
All right, Ms. Hill, have you had any contact from Mr. Behrens?
Your Honor, he did email me this morning and he thought his hearing was on the 2nd and he didn't know what to do. I told him that his hearing was this morning and to log on. Is there any way we could recall his case?
Yeah, I can wait. Oh, I'll do that.
Thank you.
State of Michigan versus Eva Kilmer, file 25-438-SM. I do see Ms. Kilmer is with us.
James Dick on behalf of Ms. Kilmer, Your Honor.
Thank you very much. Looks like we were here on July the 2nd. Ms. Kilmer requested Mr. Court-appointed counsel. It appears that Mr. Dick was appointed for that. Mr. Dick, how does your client wish to proceed today?
Your Honor, Ms. Kilmer wants to take responsibility for the allegations and address the underlying reasoning behind.
So she wants to enter a plea, or does how?
Yes.
Is that what you're? All right.
She would like to enter a plea of guilty to the allegations today.
All right. Thank you. Ms. Kilmer, let me remind you what the allegations are, and then I'm going to go over your rights and make sure that you understand what you're doing before I take a plea from you. The allegations are that this is a first technical violation. There are a number of allegations. The first one is that you failed to report for the months of May and June. The second is that you failed to provide proof of substance abuse and mental health counseling. And the final one is that you failed to complete 10 hours of community service and make payments on your fines and costs. The recommendation is that you serve 5 days in jail. If you wish to enter a plea to that, you'd be giving up your right to have a hearing as to all of those charges. Do you understand that?
I do, Your Honor.
All right. The procedural protections at a hearing include the right to have your attorney represent you at a hearing, the right to have a hearing in front of me as the judge. You do not have the right to have a jury trial. At the hearing, you could see, hear, and question all the witnesses. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At the hearing, you could testify, or you could choose to remain silent, and that silence could not be used against you. At the hearing, you'd be presumed innocent until proven guilty beyond a reasonable doubt by the probation department, and that burden of proof would remain with the probation department at all times. Finally, at the hearing, you'd have the right to automatically appeal, but if you enter a plea, you'd be giving up all of those rights. Do you understand that?
I do, Your Honor.
Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
All right. I'm going to ask you to raise your right hand so I can swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right. Go ahead and put your hand down. Has anybody promised you anything other than what we've said in court today?
No, sir.
Has anybody threatened you in any way?
No, Your Honor.
Are you making this decision to plead of your own free choice and free will?
Yes, Your Honor.
All right. I'm going to go through these allegations against you one at a time and ask you if you did that. So the first one is that you failed to report to probation for the months of May and June. Is that true?
Yes, Your Honor.
The second allegation is that you failed to provide proof of substance abuse and mental health counseling. Is that true?
Yes, Your Honor.
And the last allegation is that you failed to complete 10 hours of community service and make payments on your fines and costs. Is that true?
Yes, Your Honor.
I'm also going to give you an opportunity in just a minute to tell me any reasons for doing all of that and kind of an explanation in a minute. Mr. Dick, is there anything that you want to say first, or you want me to give her her specifics?
Judge, if you would, I'd like to speak on her behalf beforehand.
Go right ahead then, sir.
So, Your Honor, I was representing Ms. Kilmer here in a case. A lot of the issues had to do with her environment and her mental health. The court did allow her to move to Kentucky because she had a older sister who lives down there and who had made an offer for her to come and live with her, with the extension of assisting her in obtaining work, obtaining her medical services, obtaining her health insurance through the state there, and also assist her in satisfying all the other terms of her probation. So Ms. Kilmer did leave Michigan right after sentencing, as the court did allow. She moved to Kentucky with her sister. Once she arrived there, she did find herself in a somewhat unfortunate situation where everything that was said to her about the support she was going to receive by her sister did not happen. Instead, she did end up being utilized as a live-in babysitter, basically raising her nephew. This is a place where her only family or friends down there was her sister when she went. And the whole premise of her going down there was because her sister was there to support her. Because of the circumstances of her being used as a live-in babysitter, her sister did not give her rides during the workday to the facilities she needed to go to apply for her health insurance. They did not give her, or she did not give her rides to go to her medical services, any of the community service or things of that nature, although she had had the appointments and things set up initially. So things essentially fell apart there, Your Honor. The area was not walkable. She did not get a vehicle down there, and she did not otherwise have the means to get everything taken care of. Because of this, she has continued to be unmedicated, which is something she needs. At present, she does have her boyfriend who occasionally picks her up in the evenings. He did offer for her to work with him a job, cover the cost of her counseling and her medication. And because of that, she's also had an online consultation with an online psychiatrist, where it will be a self-pay program. So if with all of, we would also be asking the court to permit her to move to East Tennessee, which is about 20 minutes from her present location, with her boyfriend, which would place her within walking distance of the hospital, within walking distance of employment, within walking distance of the local college, which she could attend once she gets her mental health all situated. Your Honor, this was it was kind of fortunate that she did ask for the appointed attorney and that I was reappointed to represent her, because we did have to have some rather difficult conversations, and she did come to the realization that she couldn't just be there for her nephew. She's actually having to walk away from there so that she can get her life together. So she's going to, at this point, walk away from her sister and her nephew to be able to take care of herself should the court permit her to move. All of that being said, Your Honor, this is not something that she didn't want to get taken care of. It's something that she found herself buried. She found herself embarrassed that she had provided to probation, that she had previously had things set up and was not able to satisfy or follow through with the things that she was doing. All of that being said, Your Honor, we would ask if the court perhaps consider a 3 to 6 month extension of probation in lieu of any jail time, perhaps holding that in abeyance, and perhaps set this for a 60-day review to make sure that she has everything set up and satisfied to the terms of what she's supposed to be doing while on probation. And this is all being asked, Your Honor, with the full understanding of the time that she has previously been afforded to get everything in order. I truly believe that she didn't have, the counsel she needed to make the hard decision to walk away from her family here to get things taken care of.
Thank you, Mr. Dick. Who is the boyfriend that she's going to now want to go stay with?
She can provide the court with his name and address and everything. Would you like his name presently?
Yes, I would like his name, please.
Miss Kilmer, please.
His name is Austin Turner.
All right. The reason I asked was that there was a no contact provision with a Gavin McDoniel or McDonical. I just wanted to make sure that you weren't going backwards and having contact with people that you weren't supposed to have contact with. So, all right, what you've told me, through your attorney, Mr. Dick, does sound like an appropriate action in this case. You were sentenced in October, and here we are in August. So you basically lost 8 months, almost 10 months now. I am going to give you a chance to make up for it. So I am going to extend your probation for 8 months. And I will set a review hearing in 3 months just to see how you're doing, because you are out of state. You can still report to your probation officer via Zoom so she can check in with you on a regular basis. No, I'm not even going to do that. I'm simply going to let her, I'll let your probation officer tell me if we need to have a hearing on anything. As long as you're doing what you're supposed to be doing and you're providing proof that you're doing your community service, that you're in your mental health treatment and your substance abuse treatment, I'll and you're making your payments as required for your fines and costs. I'll let the probation officer simply monitor you, and as long as you're doing what you're supposed to be doing, we'll just leave you alone, and hopefully things will go well for you. But we will extend your probation for 6 months. I'm not going to put you in jail, given the explanation from your attorney. Ms. Hill, is there anything else that you would recommend at this point?
No, Your Honor.
All right. That will be the order of the court then. We'll simply extend your probation for 6 months. All of the other same requirements apply. Thank you very much, Mr. Dick. I appreciate your assistance today. That's all for today. Thank you.
Before we close this matter, Your Honor, would the court just require her to get permission to move from probation then, rather than?
I appreciate. Thank you very much for bringing that back up. I do think that sounds like a good idea to get her out of the current circumstances that she's in and allow her to move to a better one. If there is some concerns in the future, Ms. Kilmer, please contact your attorney. If you do need to get out of that circumstance, hopefully it becomes a good place for you to be. But I don't know this gentleman, wouldn't know him if he walked in the door. So I can't make that assessment. Contact your attorney, Mr. Dick. So keep his number handy. If there is a problem, please let him know immediately. You may also talk to your probation officer about what to do and where to go and how to do it. So those are your two resources if you need somebody in the future, if there comes a problem. All right. But yes, I will extend the probation 8 months and allow move to Tennessee. You must, if you haven't already, you must contact the probation department and give them that address in Tennessee where you intend to reside. Anything else, Mr. Dick?
Yes, Judge, you did. You said 8 months and then 6 months and then 8 months for the extension.
I'm sorry. I want it to be eight months. 8 months, just so it's very clear. And I did write 8 months down on the sentence order form. So 8 months, allow the move to Tennessee, all probation requirements still in effect.
Thank you, Your Honor. Nothing further.
All right. Thank you very much. That's all for today.
Your Honor, Mr. Behrens is now here.
Thank you. This is the state of Michigan versus Stephen Behrens, file 25-43915-SD. I do see Mr. Behrens is with us. Mr. Behrens, looks like we were here in July. We adjourned for 30 days to see what your status was regarding Harbor Hall. So where are we at with that, sir?
I'm still technically in treatment. I'm in their transitional housing right now. So it's just an intensive I guess extension of their inpatient. I am still do 20 hours of clinical hours a week. I'm still meeting with a therapist once a week, still getting drug tested a lot. It's just now I can, from 3 o'clock on, I have the ability to go work and go to outside meetings.
So you have the ability to do some of your probation requirements as well?
Yes, sir.
Work, make your payments, go to you're in your treatment program already, so that's a good thing.
Yeah, that's my main focus now because housing is covered for a little bit, and so that's my focus. Is I want to get these payments done and over with.
How long were you in the residential part of the treatment facility?
About 45 days.
And that was that was an inpatient with limited access to the outside world?
Yeah, no, the only thing we could do is just once in a while we could go to an outside meeting.
All right. Ms. Hill, do you have any objection to me saying that qualifies for sufficient for his probation violation of using kratom?
No, Your Honor, I agree with that.
All right. So, Mr. Behrens, I'm going to withdraw the probation violation.
Thank you, sir. I just want to say, like, this has been the best choice I've ever made. This was exactly what I needed. I feel capable now of keeping my life. I know things happen, but I just I'm really grateful that I got to do this.
Well, I'm pleased to hear that. We don't have enough success stories, and I'm hopeful that yours will become one of them. There's going to be times in the future where you are tempted again to fall off the wagon, and yes, I'm hopeful that you've now learned sufficient techniques and are able to withstand that temptation in the future and know if it gets too strong where you need to call, who you need to call, and what you need to do to deal with those issues. So I'm going to hopefully point you in the right direction and say, because of your good behavior, because of your attempts and looks like successful attempts to get into treatment and to do the things that you need to do, we're going to help you out by withdrawing the probation violation. You'll simply continue to be on probation with all the same terms. Ms. Hill, do you need him to contact you for anything in the near future?
Mr. Behrens, I need you to have your counselor send me an updated report, and then if you could email me your AA attendance log.
No problem. I'm sorry, I have not been keeping the attendance log. I can do that from now on.
Okay, thank you.
Actually, no problem.
All right, so the probation violation allegation is complete at this point. We'll simply withdraw it, and you will continue your probation as previously, and we'll hope that everything goes well. So that's all for today, Mr. Behrens. Thank you.
Thank you, guys. Thank you, Your Honor. I appreciate it. Bye.
Yep. Next matter is the state of Michigan versus Carissa Fennell, file 24-43361-ST. We have Ms. Fennell with us.
She is not here.
Ms. Hill, have you had any contact from her?
I have. I believe that Mr. Matisse is her attorney.
Judge,
She was sentenced
oh,
out
I'm
of.
sorry. She was sentenced yesterday. So she was just sentenced in a circuit court matter, and she was put in the Otsego County Jail.
How long is she supposed to be there?
90 days initially with upfront, and then she's able to start doing work camp and things for a part of her.
All right, looks like she was sentenced in December in this matter. It was a probation violation back in April, and then this new one in May. Ms. Hill, given the circumstances, do we want to continue with this, or do we want to just discharge her unsuccessfully?
Discharge her unsuccessfully, Your Honor. She is paid in full.
All right, let's just do that. There's no reason, if she's already doing 90 days, if she pled to this, she'd get credit for that anyway, so there's no real purpose served at this point. So we will just discharge unsuccessfully and call it a day.
Thank you.
Thank you, Aaron.
State of Michigan versus Zachary Gaylor, file 26-44618-FY.
Thank you, Your Honor. Good morning, Brian Clean on behalf of Zachary Gaylor. He appears in my office via the Zoom platform, and thank you for allowing us to do so.
This is set for a status review. Mr. Clean, how do your client wish to proceed?
Your Honor, we just substituted in, and now I think substitution was signed on July 16th. We're still awaiting some discovery on this case. I was listening to you on previous hearings, and I know you're using the September 3rd date. If it works in that schedule, that'd be fine. I checked my calendar, and my September 3rd is completely open. If we just get a little additional time.
Yeah, we do September 3rd in the afternoon.
Mr. Clayton, I see the note in our file. Are you contacting Mr. Brown? Are you waiting for Mr. Brown to get you that information?
That is correct, yes.
Okay, all right. I just wanted to make sure you weren't waiting on anything from
No,
us.
no, I was over there, and I tried to abide by them.
No, I didn't imply you weren't following the rules, but.
Okay.
All right, Mr. Clayton, September the 3rd at 1:30. We'll see you then.
All right, sir.
Have a good day.
Well, do you have Russell right there?
I do.
That's the same request. We had something to share with Mr. Fortier, and just because my week's been kind of crazy, I'm just asking for a little additional time.
Yep, let me put that on the record. This is State of Michigan versus Joshua Russell, file 26-44585-ST. Mr. Clayton, your appearance and your request.
Thank you, Brian, on behalf of Joshua Russell. He is on the Zoom platform. I saw him earlier as a participant, so he should probably join and unmute himself.
I'm here, sir.
All right.
Thank you very much. I do see Mr. Russell. Your request, Mr. Clayton, was for an adjournment?
Yes, Your Honor. Just a brief one.
Is that same date of September 3rd sufficient?
It is sufficient, sir.
All right, Mr. Russell, do you have any objection to that request?
No, I do not. I was just hoping,
Bye.
if Mr. Clayton could contact me today or do a breakout room.
I'll just call you. How about that?
Perfect. Yep, that works. Just wanted to make sure.
All right, my man.
All right.
I'll do that.
I'll see both of his clients, Mr. Russell and Mr. Gaylor, September 3rd at 1:30. Thank you all. That's all for
Thank you,
today.
Your Honor.
Yep. Next matter is the State of Michigan versus Christopher Genther. We have 4 files for that. First is 26-44765-SM, set for an arraignment. Second file is 26-44684-SD, set for a status conference. Third file is 26-44747-SM, set for an arraignment. And the last file with Mr. Genther is file 24-42658-FY, set for a bench warrant arraignment. I do see Mr. Genther is with us. Mr. Dick, are these your matters?
Your Honor, I believe that I'm presently appointed on the 26464 SD file only. Once he's arraigned, I believe I'll be appointed on all of them. Hold on a sec. My apologies. I was appointed to all of them. My apologies. At this time, Your Honor, I've not had an opportunity to speak with Mr. Genther about anything. I did mail out a couple letters. However, I still do not have a phone number for him.
All right, Mr. Genther, can you assist Mr. Dick with a phone number where he can contact you?
Yes, I think I got one of his letters, but there was a lady here that got in trouble for going into people's mailboxes and taking people's mail. So I know my
Why
mail.
don't you just give Mr. Dick, your attorney, a number where he can contact you at in the future.
Go ahead.
989-231-340-8391.
All right. So what I intend to do today, Mr. Ginther and Mr. Dick, is simply arraign him on the 2 new charges, and then we'll adjourn everything so that you have an opportunity to speak with your attorney. So that will cover the other 2 cases that we have open. One of them is simply a failure to pay. It was about $356 on that. So I'll let you and your attorneys talk about how to resolve that matter.
Excuse me, Your Honor. Is it for unpaid fines?
Yes.
They already came to my house for that bench warrant, and I paid my boss ended up coming and bonding me out and paid it came out to like over $400.
Yep. That simply keeps you out of jail while the case is being processed.
Okay.
We may be able to use that bond in the future, but I'm going to let you talk about all of that to your attorney so that he knows and you know what's going on with everything before you try to make a decision.
Okay, I just didn't know if me paying for it took care of that, so sorry.
No, not a problem. That was a good question. So I'm happy to answer that. I'm just going to give you some time to talk to your attorney about it.
Yes, sir.
Still open on September 3rd?
Yes, we are.
All right.
Yep, in the morning.
All right. We're likely going to adjourn these matters to September 3rd at 9 a.m.
9, not 10. I'm going to write that down right now.
All right. So that covers 2 of the files. Then there are 2 files that I need to arraign you on. Please listen carefully, Mr. Ginther, while I do that. First is file 26-44747-SM. The allegation is that on or about June 30th of 2026 in the city of Gaylord and Otsego County, that you did commit the offense of failing to stop after a collision. It reads that you did drive a vehicle that is a silver Hyundai upon public or private property, the Taco Bell parking lot, and then another vehicle that is a Chevy Silverado, which was attended or unattended and did fail to immediately stop your vehicle and then and there or notify the operator or owner of the vehicle of your name and address, or to report the collision forthwith to the nearest or most convenient police officer when the owner could not be located. That is a misdemeanor offense, has a maximum penalty of 90 days and or a $100 fine. Do you understand the name of the offense that you've been charged with?
Yes, Your Honor.
You understand the maximum possible penalty for that?
Yes, Your Honor.
Right now, you have certain rights. Those include the right to plead guilty, not guilty, or to stand mute, the right to have a trial by a judge or a jury, and the right to be represented by an attorney. If you cannot afford an attorney, one would be appointed for you. Do you understand those rights?
Yes, Your Honor.
I assume that you're going to be asking for a court-appointed attorney. Is that correct?
Yes, Your Honor.
All right. Because Mr. Dick was appointed on the other ones, I'm going to assume that Mr. Dick will be appointed on this one as well. As to that charge, you have the following hearing rights or trial rights. You have the right to have a trial by a judge or jury. As I said before, Mr. Dick or the court-appointed counsel could represent you at that hearing. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. At the hearing, you could testify or you could choose to remain silent, and that silence could not be used against you. At the hearing, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at your hearing, you'd have the right to automatically appeal. However, if you enter a plea in the future, you'd be limited to asking for permission to appeal, and that might not be granted. You understand the rights that I've just given to you?
Yes, Your Honor.
You have any questions about any of those rights?
No.
All right. I'm going to enter a not guilty plea on your behalf and give you a chance to speak with your attorney before you need to decide anything to do. Because this is a misdemeanor matter, we'll set a pretrial conference so that the prosecutor and your attorney can get together and try to resolve the case, and then your attorney will have a chance to speak with you about that. Do you have any questions about this charge that we've just talked about, the failure to stop after a collision?
No, Your Honor.
All right. There is a further charge, that is file 26-44765-SM-3, and that is a similar charge. It says that on or about July the 15th of 2026 in Livingston Township of Otsego County, that you did commit the offense of failure to report an accident. It says that you did, being the driver of a motor vehicle involved in an accident that damaged property to an apparent extent totaling $1,000 or more, did fail to immediately report that accident at the nearest or most convenient police station or to the nearest or most convenient police officer. That is also a misdemeanor offense. It has a maximum penalty of 90 days and or $100 fine. Do you understand the name of the offense that you've been charged with in this case?
Yes, Your Honor.
Do you understand the maximum possible in this case?
No, not that one.
This is a maximum penalty of 90 days and or a $100 fine. Do you have any questions about that?
No.
All right. This charge has exactly the same rights as I just got done explaining to you in the other case. So you have the same trial rights, you have the same attorney rights, you have the same plea rights that I just explained to you. Do you want me to explain all those rights again to you, or can you remember them?
No, Your Honor, I remember.
All right. I'm going to indicate that you're asking for a court-appointed attorney. I'm assuming that Mr. Dick will probably be assigned to this case as well. I'm going to enter a not guilty plea on your behalf in order to give you time to speak with Mr. Dick before you have to decide anything. And we'll set this for a pretrial conference so that Mr. Dick can speak with the prosecutor and see if there's a way to resolve this case and then talk to you about it. Do you have any questions for me at this time, Mr. Gunther?
No, Your Honor.
All right. We'll set this matter for a pretrial conference on that same date, September the 3rd at 9 a.m.
9 a.m.
You'll need contact with your attorney, Mr. Dick, on all of these matters prior to that so that he can talk to you about how to proceed on all of these matters. Do you have any questions for me, Mr. Ginther?
No, thank you, Your Honor.
All right. That's all for today. Please get a hold of your attorney as quickly as possible. Thank you.
All right. I think his name is, he's in Traverse City, right?
That's the office. You can just call the number. I got an office in Gaylord too, so.
Okay, because yeah, I got like a number, but it says the number. I don't know. Didn't know if that was the number for Traverse City or Gaylord. So
just call the number and we'll be in touch.
Okay, I'll call you a little bit later after court then.
Thank you.
All right. Thank you.
Thank you.
State of Michigan versus Christopher Holmes, file 25-44141-SD. Do we have Mr. Holmes with us? All right. I do see Mr. Holmes is with us. Mr. Dick, is this your matter as well?
Yes, James Dick on behalf of Mr. Holmes, Your Honor.
Mr. Kevin Michael or whoever that was.
And we do have a resolution to this matter as well. I believe this is set for a bench warrant arraignment. However, if the court would be willing to set aside the warrant, we are prepared to enter a plea today.
All right. That does appear to be appropriate. So let me make a note of that before we get started. All right, Mr. Dick, do you want to go ahead and put the offer on the record, please?
Yes, Your Honor. So Mr. Holmes is going to be pleading guilty to an operating while intoxicated in exchange for dismissal of the IBAC.
That's correct, Your Honor.
All right. Mr. Holmes, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
My understanding of the agreement is that the more serious offense of operating with a high BAC, which is what you're currently charged with, would be dismissed in exchange for your plea to the less serious offense of operating while intoxicated, which is a misdemeanor offense that has a maximum penalty of 93 days in jail and or a $100 to $500 fine. Do you understand that?
Yes, Your Honor.
And knowing that, is that what you want to do today?
Yes.
All right. You have certain rights that you'd be giving up. They're typically called your trial rights if you enter a plea today. So let me explain those to you so you can make an informed decision. If you wanted to, you could have a trial, and at trial, you'd be represented by your attorney. You could have a trial in front of a judge or a jury. At your trial, you'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent till proven guilty beyond a reasonable doubt, and that burden would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal. However, if you enter a plea, you'd be limited to asking for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Knowing all of that, do you still wish to enter your plea today?
I do.
All right. And I need to take some testimony from you. So would you raise your right hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead and put your hand down, sir. Has anybody promised you anything other than this plea agreement to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way to get you to plead today?
No,
Are you doing this of your own free choice and free will?
I am.
All right. The charge against you reads as follows. It says that on or about September 25th, 2025, in the city of Gaylord and Otsego County, that you did commit the offense of operating while intoxicated, in that you did operate a vehicle upon an area designated for the parking of vehicles, that is the Shell gas station, while being under the influence of an intoxicating liquor and or while having a blood alcohol content above 0.08 grams per milliliter. Is that what happened? Is that true?
Yes, Your Honor.
Can you tell me what vehicle you were driving at that time?
It was my girlfriend's roommate's car.
What kind of car was it? And where were you driving it at?
From her apartment to the Shell gas station.
And that was here in the city of Gaylord?
Yes, Your Honor.
That's the, which Shell station was it?
The one on, I think it's on like South Otsego near the highway.
So the South End Shell?
Yeah.
All right. And what did you have to drink by way of an alcoholic beverage prior to operating the vehicle? You know how much?
I don't remember, Your Honor, but it was too much.
Did you take any breath or blood tests after your contact with the police?
Yeah, they did blood tests.
Do you remember what the results of that testing was?
I don't remember specifically. James, my attorney, told me I think it was above a 0.3. I know it was very high.
0.329, Your Honor.
Do you have any reason to dispute the accuracy of that test, Mr. Holmes?
No, I don't.
And are you willing to let me consider that in determining whether to take your plea today or not?
Yes, Your Honor.
All right. Do either counsel have any other factual basis questions at this time?
No, Your Honor.
None, Your Honor. Thank you.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor.
Do both counsel believe I've complied with the court rule?
Yes, Your Honor.
Yes, you have.
All right. I will accept Mr. Holmes' plea to operating while intoxicated. He has told me that he operated a Subaru on his way from his apartment to the gas station at the south end in the city of Gaylord after consuming too much vodka and having a blood alcohol content of above 0.3. And so that the proper factual basis for the plea, I do believe he's given me that plea knowingly, intelligently, and voluntarily based on his answers to my questions. So I will accept that plea. Mr. Dick, I have received a substance abuse assessment. Is it your intention to proceed directly to sentencing?
Yes, Your Honor.
Ms. Brucker, have you received a copy of the Catholic Human Services substance abuse report?
I have, Your Honor, and I've reviewed it.
All right. I haven't got it today, so I'm going to take him to review that and then we'll proceed with sentencing. All right. I've had a chance to review the Catholic Human Services substance use assessment report on Mr. Holmes. That was prepared by Michelle Klein. We've also received and reviewed some additional matters involving his rehabilitation, seeking safety certificate of attendance for Mr. Holmes for 7 sessions at Bear River's Health Journey to Recovery. A letter from Kimberly Carpenter, a clinical specialist, dated August 3rd. Another certificate of achievement in the recovery program at Bear River, successful completion of 75 days in the program as of July the 20th. Another letter from Bear River Health signed by Racine Reeves, a clinical counselor, providing an update as to his program, residential treatment, and how he's done in that program. Letter dated August 3rd from Kim Carpenter. He's involved in the Mid-Michigan Recovery Services Program. Looks like a meeting verification form for AA from July 30th, 31st, August 2nd, and August 3rd. Similar for July 21, 22, 24, 25, and 26. Mr. Dick, was there any other documentation that you wanted me to review?
No, Your Honor, that was all.
All right. Mr. Holmes, I'm going to give each of the lawyers an opportunity to tell me what their recommendations are for sentencing, and then I'm going to give you an opportunity to tell me anything else that you want me to be aware of before I decide what to do. So, Ms. Brucker,
Your Honor, law enforcement were dispatched out to the South End Shell Station, report of defendant who was intoxicated in the store asking for alcohol. By the time the police arrived, he was back in his vehicle with the vehicle turned on. He was sleeping in the car. They had to wake him up. Obviously, they observed some different signs of intoxication. They ended up having to get a search warrant for his for his blood. And eventually we got the labs back. His blood alcohol content was at 0.39, which is extraordinarily high. We are requesting $322.31 to the Gaylord City Police Department for OWI reimbursement. I'd ask the court to follow the recommendations set out in the assessment. Obviously, he has a severe alcohol use issue, and hopefully he is learning from all of this counseling that he's just someone who can't drink ever again. This could have been a really disastrous situation with him driving, being that intoxicated, especially to where he doesn't remember what was happening and the store clerks had to call the police. He doesn't have any criminal history, but I don't think it'd be a bad idea, either hold some jail over his head or maybe impose a few days in jail just to get the point across in this case. And that's all I have, Judge.
The restitution amount was $321.39.
$322.31.
All right, $322.31. All right. Mr. Dick, your elocution?
Yes, Your Honor. As is clear by all of this documentation, Mr. Holmes hasn't taken this incident lightly. He and I did lose contact for a brief period, and I did receive communication from him letting me know that he was in treatment, and that's why I hadn't been able to reach him. That being said, Your Honor, he did ultimately complete many different things. He had previously completed a short inpatient and sober living. He was in sober living at the time of this incident. However, due to some bad things that had happened, there was a relapse. Mr. Holmes acknowledges that he's not somebody that can drink. He acknowledges that he does need the continued support. And Your Honor, that is why he's back into the sober living program. He was in there for 75 days. The inpatient rehab. He was in there for his days. He's in the intensive outpatient. He's in sober living. He's getting continued treatment and therapy in excess of what he's previously done because he doesn't want to be part of the criminal justice system. He wants to make sure that he is doing everything that he needs to stay sober on the straight and narrow, all while acknowledging that this could have been a significantly different incident should there have been some sort of an accident or something on the road. That being said, we just asked that the impose a probationary period, and if there was any jail to be possibly held over his head, we asked that it be in advance.
All right. Thank you very much, Mr. Dick. Mr. Holmes, is there anything that you want to tell me directly?
I know that was a horrible decision. I'm ashamed of that. I'm well aware I put people's lives at risk, and I do acknowledge that I do have a problem. I've taken lots of steps to try to get help for that, and I'm currently at the sober living, like was explained, getting help here. I'm doing weekly counseling and doing intensive outpatient throughout the week, going to AA meetings, everything like that.
My view of your criminal history is that you have a prior dismissal after a diversion for a drinking and driving related, looks like it was in, I'm guessing, Oregon, Deschutes County, back in 2000. I think it was dismissed in 2009. Is that right?
No, I don't know what you're speaking of. I've been to Oregon.
Well, I could be wrong about that because I'm just looking at the, let's see if it just says OR, so I'm assuming that was Oregon, but I don't know that for sure. Says the initial case was in May of 2007 from the Bend Police Department on a Christopher Michael Holmes driving under the influence. And then there's a Deschutes County Circuit Court, a diversion, dismissed April of 2009. Any of that sound familiar?
Nope. Wasn't me. I don't know anything about that. I've never heard anything about that.
All right. I'll assume that's correct then, that you don't have any prior convictions of any kind.
No, Your Honor. I've always had a good record. I used to be a contractor for the Department of Defense, working in IT for over 10 years, so I had to have a clean record.
Tell me why I should believe that you're going to be successful in your rehabilitation this time when you were in rehab and living at a sober living house when you went off the wagon and quite frankly dove in deeper than anybody I've seen in a long, long time.
I was 18 months sober before, about a week before that. I'd gotten in an unhealthy relationship with someone that was also in recovery. What I've learned since then is I didn't have any healthy boundaries set up. I have codependency issues that I've been working on. So that's something I'm well aware of. And going forward, I'll always put healthy boundaries in place. I'm not blaming the other person for my decisions. It's a situation I should have walked away from. I should have gotten help. And it was at a point where I had started to lose touch with the recovery community. I hadn't been going to meetings as much.
You were living at sober living, right?
I just signed on an apartment with my, at the time, girlfriend. So it was right before I moved out.
I guess my point is that you were doing everything that we would ask somebody to do in a rehabilitation program. You'd been sober for 18 months. You were living at a sober living program. You had access to all of those advantages. And then you went out and you didn't just drink, you dove inside the bottle. I mean, at a 0.329, dude, most people would be passed out stone cold on the carpet at that. And not most people, probably 99% of the population couldn't get there. And then you drove to get more. How in the world am I going to believe that you're going to be rehabilitated?
I don't know what else to say other than I am trying. I am getting help. I went to inpatient under my own accord. I living at sober living now. I know it's not a temporary thing. Like, I'm aware now that like it's a lifelong thing. I can't ever drink. I always need to be connected to the recovery community. I need to always go to meetings. It's not something I can ever stop doing.
That much is very true. Aside from the substance abuse recovery program, what are you doing for your mental health?
Working on past trauma, just trying to understand things that trigger me, how to stay away from them, coping mechanisms.
I'm not a psychiatrist, but it seems to me that somebody that had all of the advantages of rehabilitation that you have been through and who dove that deep back into substance abuse has to have some demons someplace that he's trying to run away from as fast as humanly possible. And he's using alcohol on a regular basis to try to numb himself from them. Am I wrong about that?
No, I think a lot of it was the relationship I felt stuck in. I know that's not an excuse, but that's, something I've learned later.
All right. I'm just looking for some hope that you're not just going to do this again in 18 months. I'm looking for something to say, yeah, let's do that. Let's get that issue. And again, I get it that they don't just go away. It's a long-term thing. I understand that. I run a sobriety court here. I've seen a lot of this kind of stuff. So I understand where you're going and what you're trying to get through. But I looked at your circumstances when I first saw this and went, man, this guy, he had all of the advantages and he knew right where to run back to. You got, and I applaud that, but you knew all that and you didn't just go out and drink a few things, well, I'm having a bad day. This wasn't just having a bad day. This was, I can't drink alcohol fast enough and I want to get some more so I can keep pounding it down. That just floors me that you got to that level and wanted more. So you've got some serious work to do. And it sounds to me like you're an intelligent man. And it sounds to me like when you're sober, you understand what you need to do. But you can't be taken by surprise anymore. Everything is a trigger for you. You just have to assume that. And you have to be on top of your game at all times because you just can't stop. You start drinking alcohol and you are going to kill yourself or somebody else. There's just no other way to put it. because at that level of drinking, you can't stop yourself. So the next time that you have alcohol, you are going to jail for as long as I can possibly make it happen, because you can't stop yourself. And I don't trust you right now in rehabilitation. I'm certainly not going to trust you if you violate your probation. So I'm going to put you on probation for as long as I possibly can. I'm not going to put you in jail now, because I think you went and did what you're supposed to do, which is go back to rehab. But if you break your probation in any way, I don't care if it's a half ounce of alcohol. I don't, because you can't stop. At that level of drinking, you're just a time bomb waiting to happen. And I won't have you killing yourself or somebody else simply because you got sad one day or somebody did something that triggered you. And I'm not trying to make that trivial. I understand those are real life things, but I need you to understand how dangerous you are, both to yourself and to others. So here's what we're going to do. I'm going to put you on probation for 2 years, $720 in probation oversight fees for that. There's a crime victim fee of $75, a justice assessment of $50, court costs of $300, a fine of $150, and a local charge of $15. There's also restitution to Gaylord City Police Department in the amount of $322.31. Let me add all those things up for you. It's a total of $1,632.31. You pay that over the course of probation. If you need to, you may perform community service in lieu of some of those fines and costs at the discretion of the probation department. You must enroll in and successfully complete the treatment program that's been outlined in the Catholic Human Services Substance Use Assessment. It includes a class called Prime for Life. That'll take the place of what they recommended, which is the Alcohol Highway Safety Education class and the Victim Impact Panel. You must attend outpatient substance abuse counseling and follow all the recommendations. That means as many meetings and as often as they tell you to do that. You must also attend self-help meetings 3 times per week until they tell you to stop. Your Mid-Michigan Rehab Services and MAT program should be continued as well. While you're on probation, there's no consumption or possession of alcohol or drugs. There's no entrance into a business where alcohol is served by the glass. That means no bars. Even if they happen to serve food, you can't go there. You may go to a restaurant that happens to serve alcohol. Obviously, you may not consume alcohol and you may not sit in the bar portion of the restaurant. There is drug and alcohol testing at the discretion of the probation department. In the rehab program that you're in, are you able to be released to do work or community service?
Yes, Your Honor. The intensive outpatient will be done in 2 weeks, so that'll give me more time to do so.
All right. I'm going to require you to do some work camp days so you'll be out of that in the next 2 weeks, you said?
Yes, Your Honor.
All right. Typically I require the work camp days to be within the next 30 days, but I'm going to change that to the next 60 days just so that it doesn't mess up your current substance abuse treatment program. So I'm going to say 5 work camp days. Those will be 8-hour days. You'll be able to set those up through the probation department. You'll get a copy of this sentence order, and you'll need to contact the probation department to schedule your work camp days. But you may do that within the next 60 days. I'm going to leave it at that. Much of it is what you're doing already, so you know what you're supposed to be doing there. Continue to do the good work that program requires. Get your work camp days done. It's going to take you a while to pay off your fines and costs once you're out. The biggest thing is no alcohol. Just can't do it. It doesn't matter what the reason or the temptation is. It doesn't matter if your life falls apart in the future. If you do it while you're on probation, you're going to jail for as long as I can possibly make it. Have I made myself clear?
Yes, Your Honor.
All right. You seem to me to be a guy who understands things and has just got a few demons that he needs to work on. So let's get those things worked on so that they're under your control and not the other way around. Good luck to you, sir. I hope things work out well for you.
Thank you, Your Honor.
State of Michigan versus Angela Napier, file 26-44307-SD, set for a status conference.
Yes, James Dick on behalf of Ms. Napier, Your Honor.
Yes, I'm here.
Thank you. I do see Ms. Napier is here with us as well. Ms. Napier, my staff indicates that they've been having some trouble mailing things to you. I have an address for you on 4th Street in Sheboygan. Is that accurate?
Yeah, that should be taken care of now. But and
All right.
I've been getting the emails. I gave my email address and my phone number,
Yep.
so
Yep.
at least
Well, we're happy to use that, and you're here today, so I guess I'm assuming that everything was taken care of, but I just wanted to check to make sure. So,
no,
all
yes,
right.
thank you. It was a problem.
All right, Mr. Dick, I think we were here back in July and you asked for some time, so we rescheduled to today so that you could have time to speak with your client. How do you wish to resolve this matter?
Yes, Your Honor. So today we were planning to set this for a jury trial just to keep things moving forward. However, due to another piece of discovery that I received, Your Honor, we are just asking for a rather brief adjournment, and I think we may end up with a resolution at that time. 2 weeks, perhaps, if the court would be willing to do so.
We have days left in August.
Yes, we can do August 20th in the morning.
August 20th at 9 a.m. Any conflicts with that?
Oh, sorry, Your Honor. Yes, I apologize. I am in a trial on the 20th.
All right. Let's see if we have another date.
We can do the 27th in the morning.
27th, 9 a.m.
That works. Thank you, Your Honor.
Ms. Napier, any conflicts with that date?
No, sir.
Looks like there was an arraignment back in May, so we're getting down the road a bit. So I'm going to say, Ms. Napier and Mr. Dick, if you would confer with each other very carefully, I'd like to try to resolve this case at the next hearing. So I'm probably not going to grant an adjournment if one is requested at that time. So please do your best to try to resolve this thing one way or the other. If we need a trial, we need a trial. I'm fine with that, but I just need to know which way we're going. So I'll give you your adjournment this time, and I'll see you on the 27th at 9 a.m.
Thank you.
State of Michigan versus Lexi Forcier, file 26-4437-SD, set for sentencing. I do see Ms. Forcier is present.
Good morning, Your Honor. Gabriel Matisse on behalf of Ms. Forcier.
All right, thank you very much. Looks like we adjourned from July to today's date to make sure we had a copy of the substance abuse assessment. Looks like I have received it as of yesterday. Ms. Brucker, have you had a chance to review that?
Yes, Your Honor, I've received it and reviewed it.
All right. I did not get a chance to review it yet, so let me do that, and then we'll proceed to sentencing. All right, I've reviewed the Catholic Human Services Substance Use Assessment Report. That was filed by Tracy Wheeler. Mr. Matisse, is there any other documentation you'd like me to review?
No, Your Honor.
All right, looks like there was a plea back on April the 22nd. That was to a high BAC. We adjourned today's date for sentencing. Ms. Forcier, I'm going to listen to both of the attorneys make their recommendations. Once they're done, I'm going to give you an opportunity to tell me anything else that you want me to be aware of before I decide what to do. So, Ms. Brucker, your comments?
Your Honor, law enforcement were dispatched to a single vehicle accident. Defendant's vehicle went left to center on the roadway and crashed into a ditch near a tree. She did get transported to OMH. It appeared that she was visibly intoxicated, and she did admit to the officers and to the paramedics that she had been drinking. Her blood labs were a 0.213. She does not have any criminal history, but her driver's license was expired at the time. We are requesting $100 in OWI reimbursement to the Michigan State Police. I would ask the court to follow the recommendations in the assessment for her to attend self-help meetings and to attend outpatient counseling and to have a mental health evaluation. In addition, because there was a crash, I would ask the court to either impose some upfront jail or to hold some jail over her head.
Thank you. Mr. Matisse, your allocution?
Thank you, Your Honor. This is a situation where Ms. Forcier's partner had been in a difficult relationship with her and committed suicide the night before. Ms. Forcier is not a heavy drinker by nature. She doesn't have any criminal history for this reason. This is a really tragic case, Judge. She's taken this extremely seriously. This is one of those spiraled sort of situations where she was overwhelmed. This is really traumatic incident, and this is why she landed here, Judge. I don't think any upfront jail is necessary. If we could please hold any jail time in abeyance and just let Ms. Forcier show us that she's not a risk to anyone in the community, and she will comply with whatever's ordered. But this wasn't a simple situation of somebody making a clear-headed bad decision just to get in a car after they drank. She was distraught and very upset, Judge. She's done a lot to do this. She attends recovery meetings. She's really gotten into this, and she'll be able to tell you that herself. But Judge, I don't think this is I do know it's a very serious high BAC case, but I don't believe this is your standard high BAC case. I think she was under so much emotional distress that I'd ask the court to please take that into consideration when fashioning a sentence. I'm not going to speak over Ms. Bruker, but when I spoke with Mr. Fortier on this, it didn't sound like he was seeking jail, and I know that's Ms. Bruker's prerogative, and she's allowed to ask you for that. But I feel like this is not that type of case, and that's what I'd ask the court to do.
You know what, I'm looking at my notes. I apologize. Mr. Fortier did indicate he would not be requesting jail when they did the pretrial, so I will withdraw that.
Thank
I
you, Ms. Bruker.
apologize for misleading
Thank you,
anyone.
Ms. Bruker. All right. Ms. Forcier, you have the right to make a statement to me as well. Is there anything that you want me to consider before I decide what to do?
Absolutely. I'm so sorry. And honestly, the thought of anything bad happening for me to be under the influence and hurt somebody scares me way more than jail. That's a fear. And in fact, I was drinking alone at that time, in that point in my life, after all that stuff, just because I was so unwell. And I didn't want to snap at my family or say anything mean because it wasn't their fault. And so I was trying to keep myself away and like hide the drinking. And but thankfully, I talked to the officer that day in the hospital, and they had helped me get out of that abusive situation and came to check on me, or came to do a wellness check because I found out my ex was gonna take me with him, mess me up. But I'm actually a lot better now. And I go and I pray to God a lot. And my family and friends say I'm doing a lot better. It was really bad.
I can understand that. So I just wanted to make sure I heard all of what you said.
I didn't know how to handle it at the time. And I was trying to understand, because there was such malevolence there that thought if I could understand it, I could overcome it that way. But that's not how it works. So you just got to process it and heal and forgive and accept what happened. And then ever since then, I've been doing really good. And there's no desire to even drink or numb anymore. I'm doing good.
Good. I'm glad to hear that. So what has helped you the most in your pathway to good?
I actually I ran like 300 miles, and then over by my house, there's a labyrinth with Mother Mary, and I go pray most days there.
All right. So some spiritual searching and some physical exercise is what has helped you get back in a good place?
And because I was hiding it, but then obviously I crashed my car. So my family I have a really good family, and they wanted to make sure I was okay. And my parents offered to pay for counseling, or talk therapy, but I think talking about it with somebody makes it worse. I think that God knows, and just finding joy in life again, because I'm not normally like that at all. And that was a really bad situation.
I understand the depth of that sort of situation. Unfortunately, I run into those kinds of things on a regular basis here in my job. So I understand how that sort of behavior towards you by somebody else could cause you to feel the way that you felt. And I am glad that you have now found a path towards the good, as you called it.
And I've had a lot of good in my life before that too. That was just it did a lot of damage, but now I'm getting past it. And
good. I'm glad to hear that. So I want to make sure that you stay on that path. There are times, as you said, that talking about things makes it worse, but there are times when talking about it can make it better. So I want you to keep an open mind in the future, because our mind has a way of bringing things back to us at unexpected times. So if there is a point in the future where this comes crashing back down on you, I want you to be open to counseling and talking with people, whether that's family members, whether that's a person of faith, whether that's a pastor or a counselor, whoever that you think that you can trust, who has some wisdom that can talk to you about those things. I want you to be open to that. And I think that your understanding that you were trying to hide, and that's part of what the problem was trying to hide your pain and hide your obviously proper feelings, but you went in on yourself, and that caused you to make some bad decisions. It's always better to let our family in, those closest to us, those that we trust, let them in and let them help us, as opposed to trying to do it all ourselves. So
Right.
I am going to take all that into consideration in my sentence for you today. I'm going to make it a little less difficult for you than I normally would for an offense like this, because I think that you have handled yourself well under difficult circumstances. And this appears to be, I'm going to call it a one-off, as opposed to something that you have a history of doing. So I am going to put you on probation. I'll do that for 6 months. If you complete these requirements, you have the ability to ask for that to be terminated after 3 months if you've successfully completed everything in the first 3 months. But I'll let you talk to your probation officer about that. That probation has a cost of $180. There's a mandatory crime victim fee of $75, a mandatory justice assessment of $50. There's $100 in restitution to the Michigan State Police. Court costs of $200, a fine of $100, and a local charge of $15. Let me add all that up for you. A total of $720. You can pay that over probation. You may perform some community service work in lieu of fines and costs at the discretion of the probation department. I want you to continue your treatment program that you're involved in, as recommended by Catholic Human Services report.
Okay. I appreciate it, Your Honor.
You're going to do the outpatient program. Self-help meetings are recommended at 3 times a week, and that will continue for as long as your counselor thinks that that's necessary. If your counselor says that you can do less than that, then you may do less than that, at least while you're on probation. I think it's a good idea. Number one, it gives you some information about others who have gone through similar circumstances and how alcohol has affected them. But in the future, if there is ever a temptation, it gives you people that you've already spoken with and you've already known, and you can go back to them and say, hey, I'm having a struggle here. How do I deal with this? What can you recommend? So it gives you some built-in places that you can go and people that you can talk to about your circumstances, which I think is a good thing. Obviously, while you're on probation, there's no consumption or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You may go into a restaurant that happens to serve alcohol, but you may not sit in the bar, and obviously you may not consume or possess alcohol there. There will be alcohol or drug testing at the discretion of the probation department. I'm not going to do any jail time as indicated by the by the prosecution. It doesn't appear to be necessary at this time, given the nature of the circumstances in this case. Your blood alcohol level was extremely high, and that tells me that you were incredibly emotional about this, because most people at the level that you were at couldn't have gotten there. So you had to be intensely upset in order to just drink that much alcohol. So I want you to make sure that if your emotions get the best of you in the future, you talk to your family, you talk to your therapist, you talk to your counselors, and you don't try to muscle through this or get through it all on your own again. All right, ma'am?
Absolutely.
All right.
Thank you.
A copy of this sentence order will be sent to you. You're going to need to be in contact with your the probation office about how to take care of all these requirements. Let me give you the number for them that you can call them. That's 731-0215. You can do that probably tomorrow would be the best time to give her a call for that. All right. That's all for today then. Thank you very much.
Thank you. Have a great day.
You too. State of Michigan versus Daniel Hirschberger, file 26-44675-ST, set for a status conference.
Good morning, Judge Gabriel Matisse on behalf of Daniel Hirschberger. Your Honor, I don't know if he's here today, but I haven't been able to get in contact with my client. I do have an offer and the discovery materials. However, I haven't been able to get a hold of him at the numbers that I had available.
Parker, do you see Mr. Hirschberger with us today?
No, he is not here.
All right. I arraigned him on June the 30th. He asked for court-appointed counsel, and I agreed to that. So Mr. Matisse has been appointed, but Mr. Matisse has had no contact for his failure to appear today. We're going to do an order to show cause. Hopefully we'll pick him up fairly soon. Mr. Matisse, you can have contact with him then.
Thank you, Judge.
State of Michigan versus Xander Shaler, file 26-44550-SM, set for a status conference.
Good morning, Your Honor. Gabriel Matisse on behalf of Xander Shaler, who's joined us by Zoom. Judge, I'd like to inform the court that the attorney-client relationship with Xander Shaler and I isn't necessarily bad, but the trust is not there. We just failed to establish rapport on this, and they would like a different attorney. He's got all the discovery materials. I dropped them off for him and East Jordan myself. They've been able to review the case, so I don't believe this will make the case very long. He's having a hard time making a decision on whether or not he wants to go to trial or not. And the relationship just did not establish the trust necessary for him to work with me on this, Judge.
Mr. Shaler, do you share Mr. Matisse's viewpoint?
Yes, we both agree on struggling on decisions with the case.
Is that going to be any different with another attorney?
I'd hope so.
All right, Mr. Matisse, have you discussed this matter with the MIDC?
I have not yet, Judge. This just happened yesterday evening when we were discussing the case again, and so this is the first opportunity I've had.
All right, let's do this then. Let me reset this for sometime in August. We'll try to get a date for that in just a minute. I'm going to ask you to contact MIDC as to how they wish to proceed with this. If they can do an internal change to another attorney, let's make that happen. If it requires some sort of court order, I would ask that you simply submit a proposed stipulated order for that with your client's signature on it, with the prosecutor's signature on it, and then I can assign that order if it's necessary. But if we can get it done quicker through MIDC, that I think is the best way to go. If they need some other procedure, simply let us know and we'll accommodate you on that to the best of our abilities. Let me get you a date when we're going to come back. August.
Yep, we can do 27th in the morning.
August 27 at 9 a.m. Any conflicts with that?
No, Your Honor.
All right. I'll see you, Mr. Shaler, on August the 27th. Probably not Mr. Matisse, at least on your case. That'd be with somebody else. Mr. Shaler, I am going to ask you if another attorney is appointed to meet with that attorney either by phone or in person prior to that next court date and have a good idea of where you want to go if at all possible. It's you may need to meet with that attorney a couple of times. But you need to have some intensive conversations so that you're aware of where you want to go and what you want to do when we get back on the 27th. All right, sir?
Yes. And I'm informing the next attorney.
All right. That sounds good. I'll see you on the 27th. That's all for today.
Thank you, Your Honor.
Thank you, Your Honor.
On each of them, and I'm just going to try to
check with my staff and confirm how much was paid on each file.
42932. He paid
110 on one.
43302 was 110 as well.
110 on the other. And so you paid $220 total?
Yes, Your Honor.
All right. And what is your plan moving forward? How much are you going to be making on a regular basis?
Yeah, I can still make that amount of payments each month until it's paid off.
How much? You're going to make the same payment each month, $110? So $220 total?
Yes, Your Honor.
All right. Let's do that. Bad things happen when people don't follow through on their promises to the court, though. You understand that, right?
Yes, Your Honor.
All right. So I'm going to give you an opportunity to show me that you can do what you say you're going to do. So $110 each month by the end of the month. So I'll give you a little bit longer time in. You made a good payment at the beginning of August, so you got some time before September rolls around, but you got to make the payment in that month and get this thing paid off. All right, sir?
All right.
That's all for today then. We also have 22-321069-SI set for a status conference, followed by 22-321068-SI set for a status conference, then 22-321068B-SI set for a status conference, and then finally 22-321067-SI set for a status conference. Mr. Matisse, are these yours or not?
Only fines and cost matters.
All right, Mr. Geringer, looks like you've got a bunch of unpaid files here. How are you going to resolve these?
I'm working at the moment part-time. I'm trying to make it full-time. I'm also trying to go back to college at the moment too and get my life back together. I'm struggling to find full time just because I'm trying to relocate over to Petoskey too. At the moment, I stay in Atlanta. But last Friday, I made a payment of $190 in Alpena for a nonviolent RNO that I had, and I paid that off. So that's completely taken care of now.
It looks like you've made some recent payments in these files by credit card. Is that right? August the 5th. All right. So you paid $50, it looks like, on each file.
Yes, correct.
So that's enough to buy you some time with me. But you need to be making regular payments. So what's your plan moving forward?
To continue and pay the $250 a month at the moment. At least that's all I can afford at the moment. I got a lot of responsibilities and I'm trying to stay on the correct path and make the right payments to the right people and also keep my support system going, you know? Yeah.
All right. Well, $250 a month. I know you got 5 files, so it adds up really quickly. So $50 a month on an individual file is not much, but I recognize that this is $250, and so that's a significant amount in my mind. So as long as you're making your monthly payments, that's enough to keep me off your back. And so I'll grant you the opportunity to do that, but you've got to be regular. It looks like the previous time that you paid was I had a payment in May of 23, and then September of 25, and then to yesterday. So you can't go that long not making any payments. As long as you're making something, if something comes up next month, I'm not going to accept an excuse, but if you tell me, hey, I can only pay you $10 this week, but next week I can make up the rest of the 40. I can live with that kind of stuff. So you got to be making your payments, but I can help a little bit with, hey, there's an emergency. My car broke down. I had to put $500 into the gas system or whatever.
I don't got my license, so I wouldn't be driving. But
you understand what I'm saying, though. Hey, if your house, a tree falls on your house and you got to go someplace else for a week before it gets fixed, I understand. I can help you with those kinds of things. But you've got to pay me something. You got to let me know that on a regular basis, and you got to be in contact with us if something comes up. Okay.
Yeah.
So I don't want every excuse in the book, but I'm willing to work with you if you're going to make regular payments. Does that make sense?
Okay. Yep.
All right. So I'm going to expect $50 a month on each of these files. So $250 a month. And as long as you're doing that, we'll be good. All right, sir?
Yes, sir. Thank you, Your Honor.
All right. That's all for today then.
Your Honor, I just wanted to apologize. I didn't read the rules at first, but when I first sat down, I kind of lit a cigarette and stuff, but I put it out and everything. I just wanted to be honest and apologize for it.
I appreciate that. And I saw what you did. You did it right away. So I didn't say anything about it.
Yeah.
So we're good. But thank you very much for bringing it to my attention. Yep. We're good. Thank you for the good attitude, sir. You have a good day.
Okay. You too.
Court will be in recess until the afternoon docket.